being here today, and I hope it's not a waste of your time or anybody's time today, quite frankly. So welcome, and we're going to get on with the meeting. So the first item of business we have is the approval of the minutes from February 28, 2024 and April 1st, 2024. Do I have a motion? Do I have any corrections? Seeing none.
Mr. Chairman, I make motion that we approve the minutes as presented.
I have a motion by Senator Alley. Do I have a second?
I second.
Second by Representative Hasswood. All in favor say aye. Aye. Opposed, same sign. Motion carries. Very good. Next, we will have a review of topic and resources by Elena. Elena, thank you. And by the way, thank you, staff, for all the work putting this together. I know it's looks kind of seamless out here, but there's hundreds of emails that went out, and thank you all for your work.
Thank you, Mr. Chair. Good morning, committee. My name is Elena Rudder, and I am a senior research analyst with the Legislative Research Department. And I'm just going to do a quick overview of some resources that you have in your folder and that you can also find on the S drive for committee members. And then for the members of the public, it's also on the legislature's website under today's meeting day. So in your folders, you should have a variety of information. So the ones I'm going to cover now are ones we're not presenting, but are just there for your reference. So first, after the minutes, you should have a copy of the LCC request letter. And we requested 2 days, and it includes the statutory charge of the committee, which is to recommend modification of proposed gaming compacts and to meet, discuss, and hold hearings on issues concerning state-tribal relations. The committee is also permitted to establish and transmit to the governor proposed guidelines reflecting public policies and state interests that the committee will consider in reviewing proposed gaming compacts, make recommendations to the governor about gaming compacts, and the collection of state sales and excise taxes of non-gaming goods and services, and then hold public hearings, and then generally make recommendations concerning state and tribal relations. After that, there should be a memo from KLRD, and it is just an additional resources memo. So this contains, on the electronic version, these are linked. So there's links to state and federal agencies and offices that work in state tribal relations areas. There's links to the state gaming compacts. And then there's also some brief overviews of some federal laws. It's not an exhaustive list, but there are quite a few listed in the memo. And then on page 7 of the memo, it starts with recent U.S. Supreme Court decisions. So we included recent U.S. Supreme Court decisions from the past 5 years, so 2019 to 2024. And then it ends with recent executive orders and presidential memoranda starting in 2021 through 2023. So that is available to you. And if you have any questions, we'd be happy to answer them and get back to you with more information if you want to. And then next is maps of the tribal reservations. KLRD made these, like people who helped with redistricting helped make them. It was something that you had asked about in a previous meeting, so we wanted to make sure it was included. Also from a previous meeting, you should have a memo from Jason Long in the revisor's office, and it is the review of gaming compacts. So he included this in the April meeting, but we just wanted to include it again so you have it for reference. And then Jason and the revisor's office also prepared a memo on the summary and implications of the West Flagler Associates case, which has to do with sports wagering and remote sports wagering. And that is it for the resources that are included that we're not going to talk about. But if you have questions, we'll be happy to get back to you on that. And if I'm not going to speak for the revisor's office, but if you have questions about their memo, I'm sure they would also help answer those.
Committee, are there questions? Representative Hastwood.
Thank you, Mr. Chair. Was there a summary, or is there a summary put about Kansas tribal history, legislation, back when Kansas was a state, and what did that history look like, or before Kansas was a state?
We did not prepare one of those, a memo on that topic, but I think one of the conferees today has some information, some historical information, and we can also add to that if you would like.
Thank you.
Committee, further questions? All right, very good. Thank you.
Thank you.
Thank you very much, Elena. Okay, next we have Kate. Thank you, Kate.
Hello, committee. Good morning. My name is Kate Smeltzer, and I'm a research analyst for the Legislative Research Department as well. I'm providing a lengthy overview of the history of the Joint Committee on State Tribal Relations. So hang in there. There's a lot to say. To begin, in 1999, the Joint Committee on Gaming Compacts was reconstituted to become the Joint Committee on State Tribal Relations through the enactment of HB 2065. This memo is to highlight the topics of non-organizational meetings, so that's what we're going to be focusing on. We're going to start with the most recent year, so this year, 2024. So far, you all have met twice, once for organizational purposes and again to propose amendments to a gaming compact between the state of Kansas and the Iowa tribe of Kansas and Nebraska. Two resolutions were introduced recommending the amendment, and on April 2nd, the resolutions were adopted. In the 2023 interim, the committee met for 2 days with the charge to review and propose gaming contracts, hold hearings, and discuss issues concerning state and tribal relations. The first was used to elect committee membership, and day 2 was utilized for consideration of a proposed amendment to the gaming compact between Prairie Band Potawatomi Nation and the state of Kansas, and also to review the committee's statutory responsibilities. The committee recommended the approval of the proposed amendment and introduced 2 resolutions to that effect. Moving way back to 2006, the committee met twice, during which they heard a revisor of statutes brief on the status of 2 congressional bills, both of which would have prohibited lands from being placed into trust, a review of state police powers on reservations and recent legislation, a tribal litigation overview, and a Kansas Department of Transportation and Prairie Band Potawatomi Nation discussion about tribal cooperations with the state. The committee made the following recommendations to the LCC. A Senate bill be pre-filed that would require insurance companies to report liability insurance for state police powers on reservations to the Office of the Attorney General. That KLRD and the Department of Revenue obtain information on resolution of the license plate issue in other states and report that information to the committee members by December 15th. There's further context about that in the memo as we get further in. And finally, the Senate Transportation Committee reached consensus with interested parties to solve the Indian license plate problem and to recommend a bill to accomplish the task during the 2007 legislative session. Moving back to 2005, the committee met once during the interim, during which they heard a brief on proposed gaming compacts submitted by the governor in 2004 and 2005 between Sac and Fox Nation of Missouri and Kansas and Nebraska, the Kickapoo tribe in Kansas, and the state of Kansas. A brief on the status of proposed state-owned and operated destination casinos where tribes are designated as casino managers, an Iowa tribe proposal on state-owned casinos in South Central Kansas, an update on litigation dealing with motor fuels and reservation license plates, an NCSL and NCSI update on the Kellogg Foundation grant dealing with the State Tribal Relations Project, a Kickapoo tribe request for more gaming to improve the economic situation on the reservation, a Prairie Band Potawatomi Nation opposition to state-owned and operated destination casinos, a review of the 2004 House sub for Senate Bill 9, and the committee ended by making the following conclusions and recommendations. The committee recommended that the 2004 House sub for Senate Bill 9 be clarified to provide verification by the Attorney General's office that a tribe carries the required liability insurance coverage for law enforcement. Moving further back to 2004, the committee met 4 days, during which the committee heard a brief regarding statutory framework, tribal gaming compact timelines between Sac and Fox Nation of Missouri and Kansas and Nebraska, the Kickapoo tribe in Kansas, and the state of Kansas, a brief regarding 2004 Senate Bill 9, and a review of the Attorney General Opinion Number 2004-29. This year, the committee made no recommendations or conclusions to present to the LCC. Switching on to page 4, so we're moving right through. 2003, the committee met 4 days during the interim of 2003 and heard the following. I won't go through the whole list, just a few highlights. An update from various commissions and agencies, updates on the status of tribal-related litigation, information about state programs and proposals, an NCSL review of current joint projects of NCSL and NCAI, a brief regarding the impact of historical preservation laws on the new casino operations in Kansas City, an update on programs from the Department of Social and Rehabilitation Services, a review of tribal-related issues as charged by the LCC to discuss the issue of placing lands into trust. And the committee made the following recommendations. The committee recommended that the House Committee on Federal and State Affairs continue to work the 2003 House sub for Senate Bill 9, which relates to the jurisdiction of certain law enforcement officers. The committee, with the approval of the LCC, also sent a letter to the members of the Kansas congressional delegation seeking their support in establishing actions of the U.S. Department of the Interior, establishing a congressional inquiry, into certain actions of the U.S. Department of the Interior. And the committee will continue to monitor the controversy between the South Lawrence Trafficway and possible impacts on the Baker Wetlands and Haskell Indian Nations University. Additionally, the committee will continue to monitor the status of tribal-related litigation. In 2002, the committee met 5 days and heard various things, including input regarding various topics and issues from the 4 resident tribes, a review of the status of tribal-related bills considered in the 2002 legislature, updates on the status of tribal-related litigation from the Office of the Attorney General, a review of an NCSL publication on tribal relations with states, and various testimony relative to different projects, decisions, plans, and proposals. The committee ended by recommending legislation authorizing certain tribal law enforcement officers to exercise their law enforcement powers. The bill would apply to only the 4 resident Kansas tribes, and the bill would clarify that tribal law enforcement officers must complete initial law enforcement training and any continuing education that is required by statute for law enforcement officers. Okay, moving on to 2001. We only have 2 more years. The committee met for 5 days in the 2001 interim. The committee heard a review of tribal-related bills considered in the 2001 legislative session and about multiple topics. To highlight a few, the committee heard about pending federal legislation that would impact Kansas, a review of the Kickapoo tribe's efforts to develop a long-term project to supply adequate water to the Kickapoo Reservation and other areas of northeast Kansas, legislation proposals concerning tribal taxes and license plates, and a presentation by NCSL on the state tribal projects. The committee concluded by recommending the introduction of 2 bills for consideration during the 2002 the 2002 session, and information on those 2 bills are on the next page, on page 7. So we're going to move to 2000. Woo! In 2000, the committee met 4 days in the interim. Multiple presentations were heard, but to highlight a few, the committee heard about information regarding the drought conditions experienced by Northeast Kansas and the Kickapoo tribe, a brief regarding payments in lieu of taxes, information relating to the cross-deputization of tribal law enforcement officers in Brown and Jackson counties, and a request by the Attorney General of Connecticut for a moratorium on tribal recognition decisions by the Department of the Interior. The committee made multiple recommendations, including, I'm not going to read them all, I'm just going to read a couple. The committee supported the Attorney General of Connecticut in his request for the U.S. Department of the Interior to impose a moratorium on federal tribal recognition decisions until the decision-making process can be reviewed by a national commission, and joins the governor in opposing the Department of the Interior's proposed rules and regulations regarding to land trust requests by tribes. Additionally, the committee encourages the Kansas congressional delegation to support a payment in lieu of taxes for those counties losing tax revenue from lands placed in trust for a tribe. And finally, 1999, we've made it to where we all started. The committee met for 11 days in 1999, during which the committee had multiple tours and heard about multiple state agencies and commissions. The KBI reported regarding prior efforts relating to the background checks on casino management and employees. The Department of Revenue provided testimony regarding a review of litigation concerning states and tribes. The Kansas Department of Social and Rehabilitation Services presented information regarding the coordination efforts between tribes and SRS and the status of various programs available to tribes. The Department of Education reviewed the role of the department in providing tech assistance to public schools with Native American students, as well as federal Title IX funding. Additionally, the committee heard a staff brief overviewing various provisions, federal regulations, court cases, and other topics. And they heard the appointment of a subcommittee on state tribal gaming compact guidelines. The committee concluded that there are a number of areas in which tribal relations have been productive and beneficial to both the state and the tribes. The committee was of the opinion that these mutually beneficial areas can be the basis of future positive relationships as well. Examples of these relationships include the coordinated efforts of SRS and the 4 tribes, the newly formed Kansas Office of Native American Affairs, the Riparian Buffer Initiative undertaken by Kansas State University on the Potawatomi Nation, the Tribal Law and Government Center program at the University of Kansas School of Law, and the Tribal Management Program at Haskell Indian Nations University. The committee also requested that the reviser of statutes prepare 3 bill drafts to review by the committee in January. And I've included information about those drafts below on page 10. And with that, I will stand for any questions.
Any questions? Senator Alley.
Thank you. Thank you for that brief. It was brief.
I tried real hard.
One question on the payment in lieu of taxes in those counties. How long did that payment in lieu of taxes last?
That's an excellent question. I might follow up with you about that. I don't have that information with me at this moment.
Any further questions? Kate, I have one. What is the process for a new tribe to be recognized in Kansas?
That is also an excellent question. I'm going to possibly refer to Elena if she's got the information for you. She does.
Mr. Chair, thank you. Elena Rutter, Legislative Research. There is no formal state recognition process in Kansas. There is a federal process. In one of the memos that I included, the additional resources memo from KLRD, there is a federal law that details how tribes become federally recognized, and there are 3 options. There's the federal acknowledgement process, an act of Congress, or a decision by a court. So those are the 3 ways that a tribe would become federally recognized. And then there's no formal process in Kansas.
So
For just state recognition, sorry.
many of you committee members have probably been approached by a tribe wanting to be recognized on that. And the way they explained it to me was the governor's office had not recognized them or turned down their application. But she really doesn't, according to this, she doesn't have any say in that. Is that? That's okay. I mean, I'm not trying to put anybody on the spot. That was what was told to me. And Justin?
Mr. Chair, I think Jancina Warrington with the Office of Native American Affairs will speak a little bit to that, into that process.
Very good. Thank you. Thank you very much for clarifying. You're off the hook. Representative Bacala.
Thank you, Mr. Chair. Based off that comment, I understand we'll be discussing it later. This is just to prepare unless somebody knows the answer now. Do the tribes, are they able to opt out of that Fed regulation, being that state doesn't have a law, and being that they would be the ones that would make the decision, the tribal council, whether or not a new tribe could be introduced? So is the authority back with the tribal council, being that the state doesn't have any regulations, but yet the tribal council has a lot of exceptions on their land? That's my question.
Okay. So is anybody prepared to answer that question? Representative Hasswood.
I have a quick comment on the discussion. So I think we're talking about a tribe that's trying to be state recognized or federally recognized, and I think those are different processes that our expertise today might be able to emphasize more on.
I'll probably have to defer to Jancita on that. If I'm understanding your question is, can the tribe opt out of the federal process for the state for federal recognition?
Well, the question is that being that the tribe on their land and within their organizations have a lot of authority, we have no state law referencing new tribal introductions other than the federal law. So is it that decision become the decision of the tribal council and not the state?
I'll have to research that. I couldn't tell you off the top of my head.
I'm kind of surprised we don't have a process on the state level that recognizes them. But so I guess by that, if they're federally recognized, we would recognize them.
I don't know, I'm not aware of a state process for recognition. Jancita might be able to provide more context there. If they are a federally recognized tribe, I don't know if we have any say as to whether or not we can not federally recognize them like that. I think if they're federally recognized everywhere, if that makes some sense. So they might not be a federally recognized tribe in the state of Kansas. And I don't know, maybe Jancita can add more context of like what it would take to be, to go from 4 tribes to a 5th tribe or something like that. I don't know.
Well, that was Representative Akala.
Who are we referencing that'll be able to explain that? My colleague brought up, this would be discussion later. Who is the individual on here that?
I see Russ Brand and Chairman Rupnick back there as well.
All right, thank you.
I think we'll just wait for some comment. Maybe it'll be clarified in some of the testimony later on today. Representative Hasswood.
Thank you, Mr. Chair. In this brief, it talks a little about the Lawrence South Traffic Way. I'm curious if you can provide more information on that background, and I know that's still currently an issue today.
If I may, I think I have some information about the, let's see here. My notes are all over the place. It was about the water, right? I'm so sorry, Representative.
Yeah, the Baker Wetlands.
Yes, okay. I actually have some information on my computer, some documents. Can I send those to you? And I will send those to the rest of the committee as well about the Baker Wetlands.
Absolutely.
Perfect.
Thank
Thank
you.
you so much.
Very good. Thank you, Kate. Committee, further questions? Seeing none, we'll move on. Elena?
Thank you, Mr. Chairman, members of the committee, Elena Rudder, Legislative Research. I am going to discuss the state tribal legislation from 2013 to 2014 memo with you, and then I also have a table of state tribal legislation enacted in other states for the past 5 years. So I will start with the memo about Kansas legislation from 2013 to 2024. This memo provides brief summaries of legislation related to state tribal relations that have been introduced or passed in Kansas since 2013. There are links for every bill if you're using the electronic versions that will take you to the bill page on the legislature's website. And then in the memo is just a brief overview of each bill, and if the bill became law, then the bill summary that KLRD prepares is provided. So in 2013, HR 6008 designated February 6, 2013 as Native American Legislative Day at the Capitol. And there was also a bill associated with that on page 2, SB 111, which designated the first Wednesday of February 2014 as the first, and each year thereafter as Native American Legislative Day. So it started February 6th, and then the legislature passed a bill that would also make it a yearly day at the Capitol. In 2013, the legislature also passed House Bill 2120, and this bill would have amended the criminal code concerning the collection of DNA samples by the Kansas Bureau of Investigation, gambling crimes, and a special sentencing rule related to firearms. In the area of gambling crimes, the bill would have amended the definition of bet to provide that a bet does not include a raffle, which is defined in the bill as a fundraising event in which participants donate or agree to donate something of value for an opportunity to win something of value. Winning opportunities are presented by tickets differentiated by sequential enumeration. Winners are picked by random drawing of tickets or some other similar method of determining a winner, or by a race utilizing inanimate objects floated along the river, stream, canal, or other body of water, and the raffle is conducted for the benefit of a nonprofit organization, a state or federal agency, or a political subdivision. This bill was vetoed by the governor. And then in 2015, Senate substitute for House Bill 2124 was passed by the legislature, and House Bill 2124 amended statutes prohibiting smoking in an enclosed area and at public meetings. They added an exemption for a separately ventilated portion of a medical or clinical research facility. And then the bill also added definitions of units sold and added definitions for Indian tribe and qualified tribal Indian land. If you want to know everything else about that bill, it's all listed from the bill summary, but those are the things that pertain most to this committee. Also in 2015, the legislature introduced Senate Bill 203, and this bill would have authorized the governor, subject to ratification by the legislature, to negotiate and execute an agreement with the governing body of any federally recognized Indian tribe within the state concerning the collection and dissemination of any cigarette tax or other tobacco tax and escrow collected pursuant to state law on the sales of cigarettes, cigars, and other tobacco products sold on the tribe's federally recognized reservation. This bill died in committee. In 2016, House Bill 2552 would have changed the designation of Columbus Day to Indigenous Peoples Day. This bill also died in committee. In 2016, Senate Bill 484 was passed, and it approved and adopted by reference as state law the compact relating to the cigarette and tobacco sales, taxation, and escrow collection between the Prairie Band Potawatomi Nation and the state of Kansas. It was printed in, and the compact was printed in the House Journal, the Senate Journal, and the Kansas Register. Also in 2016, Senate Bill 485 was passed by the legislature, which approved and adopted by reference to state law the compact relating to cigarette and tobacco sales and taxation between the Iowa tribe of Kansas and Nebraska and the state of Kansas. This one also published in the House Journal, the Senate Journal, and the Kansas Register. In 2017, there was a House resolution passed that recognized the Etzanoa Conservancy for its work to uncover the history of the great Native American settlement of Etzanoa. In 2017, House Bill 2073 would have changed the designation of Columbus Day to Indigenous Peoples Day. This bill died in committee. Also in 2017, House Bill 2147 was passed by the legislature. And 2147 concerned the Native American Veterans Income Tax Refund. And so included in the bill summary for 2147, there's the legislature's finding and declarations, information about the refund, who is eligible other than a veteran, the Native American Veterans Income Tax Fund, which was created, and then a report from the Secretary of Revenue to the House Committee on Veterans and Military, the House Committee on Appropriations, and the Senate Ways and Means Committee. There's also a definition of Native American tribal lands, and then the Secretary of Revenue was given the authority to adopt rules and regulations to administer the refund program. And one last bill in 2017 was SB 202, which approved and adopted by reference to state law, the compact relating to cigarette and tobacco sales, taxation, and escrow collection between the Kickapoo tribe and the Kickapoo tribe in Kansas and the state of Kansas. It also added and approved, again by reference of state law, the compact relating to cigarette sales, taxation, and escrow collection between the Sac and Fox Nation of Missouri and Kansas and Nebraska and the state of Kansas. This was published in the Kansas Register as well. In 2018, House Bill 2498 prohibited state agencies and municipalities from prohibiting individuals from wearing tribal regalia or objects of cultural significance at public events. The bill defined the terms municipality, public event, and state agency. And at the top of page 8, the bill also stated that the Kansas legislature declares the purpose of the bill is to help further the state's recognition of the distinct and unique cultural heritage of Native Americans and the state's commitment to preserving Native Americans' cultural integrity. The next bill on page 8 is Senate Bill 277. And this bill died in committee, but it would have extended full faith and credit to orders, judgments, and other judicial acts of tribal courts of any federally recognized tribe pursuant to rules adopted by the Kansas Supreme Court. In 2019, there was House Bill 2009, which again would have changed the designation of Columbus Day to Indigenous Peoples Day, and the bill died in committee. In 2020, House Bill 2443 would have provided that the following persons are eligible for resident tuition rates at any state educational institution under the State Board of Regents. And the persons eligible for resident tuition rates included any person who is attending or has attended Haskell Indian Nations University and who is enrolled as a member of a federally recognized Native American Indian nation or tribe, and any person who is enrolled as a member of the 4 tribes in Kansas, and that was regardless of where they resided prior to admission. This bill died in committee, but if it sounds familiar to you, a similar provision was included in the appropriations bill this past year, and it's included in this memo as well, and I'll get to it. Also in 2020, Senate Bill 455 died in committee, but it would have authorized the Attorney General to coordinate training regarding missing and murdered Indigenous persons for law enforcement agencies throughout Kansas. House Bill 2006 in 2021 died in committee, and it would have changed the designation of Columbus Day to Indigenous Peoples Day. In 2021, House Bill 2008 did authorize the Attorney General to coordinate training regarding missing and murdered Indigenous persons for law enforcement agencies throughout Kansas in consultation with Native American Indian tribes, the KBI, the Law Enforcement Training Center, and other appropriate state agencies. So it didn't pass in 2020 and then did in 2021. Also in 2021, House Bill 2408 was passed by the legislature, and it authorized and directed the executive director of the Kansas State Historical Society to convey by quitclaim deed a 9.86 acre parcel of land in Doniphan County to the Iowa tribe of Kansas and Nebraska. Similarly, in 2022, SB 405 authorized the executive director of the Kansas Historical Society to convey by quitclaim deed a 0.52 acre parcel of land in Johnson County to the Shawnee tribe. In 2022, SB 451 became law, and it removed a requirement for which a Kansas resident must provide satisfactory proof that the person is at least 1/16 Indian by blood for purposes of receiving a free permanent license to hunt, fish, and fur harvest in the state. A note on that bill at the top of page 10 is that it did retain the additional requirement that a person must maintain enrollment in a tribe, a federally recognized tribe, to get the free hunting, fishing, fur harvesting license. And then to the most recent biennium in 2023, Senate sub for House Bill 2058 was passed by the legislature, and that amended law authorizing any gaming compact concerning sports wagering to include provisions governing sports wagering outside of the boundaries of Indian lands. And there were 2 resolutions that were introduced and passed in 2023, which approved the gaming compact amendment between Prairie Band Potawatomi Nation and the state of Kansas. Also in 2023, there was a bill that died in conference, Senate sub for House Bill 2070, and this would have specified that orders granting custody for adoption involving a child who is Indian, then the Federal Indian Child Welfare Act would apply instead of the state sync code. And in 2023, also, there was a bill that would have enacted the Kansas Indian Child Welfare Act, and that bill died in committee at the end of the biennium. In 2024, there were 2 more resolutions approving the gaming compact between the Iowa Tribe of Kansas and Nebraska and the state of Kansas. And then there was a provision in House Bill 2560 that had to do with banking and whether certain minors needed a cosigner or not. And in 2560, it was determined that the requirement to have a cosigner did not apply to minors in the custody of a federally recognized Indian tribe in Kansas. And then the final 2 bills on page 11, House Bill 2772, again would have established the Kansas Indian Child Welfare Act. And that bill died in committee at the end of the biennium. And then Senate Bill 28 is the appropriations bill for this year. And that, as I mentioned before, is about resident tuition rates. There was a provision, I think it's 116F in the bill, that says the following persons are eligible for resident tuition rates at a post-secondary educational institution as defined by Kansas law, regardless of the residence of such person prior to admission. So it's any person enrolled as a member of one of the 4 federally recognized tribes in Kansas, and then any person who is enrolled as a member of an indigenous nation with historical connections to Kansas territories, including any federally recognized tribe containing 1 or more references to the following tribal affiliations within such tribe's name. And all of those tribal names are listed on the bottom of page 11 through page 12. It's been a pretty busy 10 years. And I'm happy to answer any questions you have on that. If not, I can do a brief overview of the table.
Committee questions? Justin?
Thank you, Mr. Chair. Elena, do you know, in your review of those bills and the statutes that have been passed, has there been a consistent definition of federally recognized tribe? I'm looking at on page 9, 2022, and it appears to define federally recognized tribe by reference to a Department of Interior list. So I don't know if that's sort of the standard approach. If that's how the revisers have consistently interpreted it. Oh, can you hear me now?
I believe so, but I'll have to double check that, and I will ask the revisers to make sure as well.
Any further questions? I have one.
Okay.
Real quick. So on page 2, the bill was vetoed by the governor.
Yes.
Was there any reason given for that?
I have it on my laptop, so I can send it to you, the veto message, I believe.
If you'd send
Okay.
it to the committee, that would be great.
Yep.
Representative Hastwood.
Thank you, Mr. Chair. Since this list only goes back 2013, why does it only go back to 2013?
So I was using NCSL as a resource, and they have a state tribal archive database. And so it goes back to 2010. But I did about 10 years, and I can go back farther as well. Also, given the time that we had and all the things we were working on, I tried to narrow the scope. But I can go back farther if you would like more information, for sure.
Is that available online as well? Like a full list?
I'm not sure. On this table, there's included a link to the NCSL statewide tribal legislation database, and that goes back to 2010, and you can filter by state and type of bill. And then we can go back farther too if you want. If for just Kansas, we can try and go back farther, and then we can post it on our website as well.
Okay, thank you.
Any further questions? Okay, very good. Thank you.
And then just the table includes the past 5 years of bills that have been, and resolutions that have been passed in other states. And the,
You hang on just a second.
Yep.
I think we need to find that first.
oh, oh, it's,
Okay, did everybody find theirs? Okay, very good.
Okay.
Now continue.
sorry about that. So this table contains bills and resolutions passed in other states from 2019 through 2024. We pulled this information, as I said, from the State Tribal Archive Database from NCSL. At the top is a link, so when you're looking at the electronic one, you can just go right there, and you can filter by state, you can filter by bill topic, year, whether it was just introduced or enacted, if it's pending. All of those things are filters that you can use. Some of the topic areas that other states have passed bills in include state and federal recognition, historical issues, government-to-government relations, health and human services, education, economic development, environment, natural resources, taxes, gaming. And I think there's also a miscellaneous category on NCSL for everything that doesn't fall into those categories. Not all 50 states are included because not all 50 states have enacted legislation in the past 5 years. So some of the big ones that have multiple bills in this time frame include California, Maine, New Mexico, Montana. And they range at anywhere from, like I said, special recognition. So establishing November as Alaskan Native Heritage Month, to very specific tax things or environmental and natural resources issues. And if you have any questions about any of these bills, I'd be happy to provide you more information. If there's one specifically or a few that you would like to know more about, we can provide you those bills and other documents that the state might have prepared for them.
Very good. Thank you. Committee, further questions? Seeing none? Very good. Thank you, Elena. Janacita, very good. Thank you for being here today. I think we'll just wait till the end. Will that be okay? And hopefully we can remember our questions.
Oh, I'm sorry. I didn't think it was on. Okay. The Kansas Office of Native American Affairs is responsible for maintaining, strengthening, and enhancing the state's government-to-government relationship with the 4 sovereign nations of Kansas. The KNA office works to strengthen the state-tribal relations by providing state agencies with education on laws and regulations, that affect state issues to ensure tribal voices are recognized in state policymaking decisions and that those decisions do not infringe on tribal sovereignty. Additional responsibilities of the office include assisting state agencies in implementing tribal consultation and outreach. Activities to ensure access to state services, coordinating intergovernmental communications to enhance and strengthen the relationship with the state, the tribes, and both federal and state agencies, providing counsel to the governor and state agency leaders on laws and policies related to or impacting tribal nations, and leading consultations, engaging in collaborations, and providing coordination, support, education for state agencies to assist in the relationship building with the tribal leaders in areas of mutual interest. The office recognizes the inherent sovereignty of the Kansas tribes and works only with the constitutionally elected tribal officials. The office does not serve individual tribal members. The KNA office assists with issues on tribal lands only at the request of the elected officials. We help to identify and streamline processes while developing opportunities for forums to address policies and program challenges and services that support the needs of the tribal nations here in Kansas. And we assist tribal governments and organizations to access programs and services throughout state agencies. A few of the initiatives for the KNA office for 2025 include reinstituting the Native American Law Symposium that once existed here in the state, and also now assuming the responsibilities of the Native American Legislative Day at the Capitol event. I'm often asked, where are the tribes located here in the state? And I understand that you have some more detailed information as far as maps and different information in your packets, and so I'll let you review those and refer to that for the future, but I just wanted to provide a little bit of information about each of the tribes. The Prairie Band Potawatomi, their treaty of 1832 established their original 30 by 30 mile reservation, and today they reside on an 11 by 11 mile reservation in Jackson County. The Kickapoo tribe, the Treaty of 1832 established their original reservation, and the 1854 treaty provided terms of the reservation they currently reside on in Brown County, Kansas. The Sac and Fox tribe, their Treaty of 1837 removed them from Iowa to Kansas, and their 1861 treaty established their original reservation, and they reside on a reservation in Brown and Donovan counties today. The Iowa tribe, their reservation is a little bit different than the others, being that it encompasses both the state of Kansas and the state of Nebraska. The Treaty of 1836 established their original Kansas reservation, and the treaties of 1854 and 1861 reduced their reservation lands, and the latter provided lands that established the Sac and Fox Reservation. The 1861 treaty reduced their lands to 12,038 acres as the reservation that they currently reside on in Brown County, Kansas, and Richardson County, Nebraska. Those are the 4 federally recognized tribes that we have here in Kansas. It's also important to know that the Wyandot and the Delaware tribes are both federally recognized tribes of the state of Oklahoma, but both of those tribes do have tribal trust lands here in the state of Kansas. What is a treaty? Because I mentioned that's how and what established all of the reservation lands was have to do with jurisdiction and other topics that I'll cover. So I wanted to just review what a treaty was, which was a contract between nations. In the context of tribal nations, treaties are contracts between a tribal government and the federal government. Before treaties come into effect, they must be ratified by the United States Senate. There were 370 treaties with tribes that were ratified by the United States Senate between 1776 and 1871. 45 of those treaties were negotiated but never ratified. In 1871, the United States ceased treaty making with tribes. Treaties are significant in defining the relationship between tribes and the United States government. Treaties serve as the basis for tribal rights to territory, water, religious freedom, jurisdiction, hunting and fishing rights, and numerous other rights. Treaties affirm an agreement made by the United States with a sovereign nation and signify the fact that the United States legally recognizes tribal nations as sovereign political entities and that there remains an ongoing obligation to recognize and uphold the terms of that agreement. Treaties remain the supreme law of the land. Federal recognition is something that we had previously touched on, and I would like to expand a little bit about what that process looks like. Federal recognition is the legal acknowledgement of the sovereign and separate political status of tribes by the federal government. It establishes a political and legal relationship between a tribe and the U.S., which carries rights and responsibilities for both parties. Federal recognition permits tribes to access certain federal resources that trigger the operation of an entire body of law known as Title 25 of the Code of Federal Regulations. How do tribes become federally recognized? Most tribes have gained their federal recognition based on a treaty. There are 3 other ways that a tribe can gain federal recognition: an act of Congress, a presidential executive order, and the federal acknowledgement process found in Title 25 of the Code of Federal Regulations, Part 183 specifically defines that process. Part 183 governs the United States Department of the Interior's administrative process for determining which groups are Indian tribes within the meaning of federal law. Administered by the Office of Federal Acknowledgement, current procedures require petitioning tribes to meet 7 mandatory criteria to become federally recognized. To qualify for federal acknowledgement, groups must establish a substantially continuous tribal existence and have functioned as an autonomous entity throughout history until the present. The DOI does not grant a sovereign status or powers to a tribe, nor does it create a tribe made up of Indian descendants. As of January 8th, 2024, there are currently 574 federally recognized tribes in the United States. In January of every year, the United States Department of the Interior publishes an official list of the federally recognized tribes, and that list is the list that is often referred to and acknowledged in law when recognizing and looking for what tribes exist. What is tribal sovereignty? Tribal sovereignty is the inherent authority of tribes to govern themselves. Tribal sovereignty has existed prior to colonization. The United States Supreme Court has acknowledged that tribal governments are the oldest sovereigns on the continent. Tribal sovereignty predates the sovereignty of the United States. United States law recognizes that each federally recognized tribe's sovereignty is inherent, meaning that tribal sovereignty is not derived from an outside legal source, such as the U.S. government or an earlier colonial government. Tribal sovereignty includes the right to assert independent nationhood and govern itself, establish its own form of government, determine its own citizenship or membership, enact laws and legislation, establish a judicial system including law enforcement and tribal courts, preserve its unique culture, and to control its own economy. The federal government recognizes and affirms the political status of each tribe as a unique sovereign government. Recognizing tribal sovereignty, both federal and state executive agencies deal exclusively with elected tribal leadership. All 4 of the nations in Kansas are federally recognized tribal nations. How do Kansas tribes operate? In the era of federal policy known as reorganization, tribes were required to reorganize their governments using a boilerplate model similar to the United States Constitution. Each tribe in Kansas operates according to a unique tribal constitution that is approved by the United States Secretary of the Interior. The 4 tribal councils in Kansas serve as both the executive and legislative bodies of the tribe. Each tribe has a separate judicial branch of government. Tribal membership. Every federally recognized tribe has the sovereign right to determine its own membership. In 1978, a Supreme Court case affirmed tribes retain full control of this right. Tribes have a membership section in their constitution that provides its unique membership requirements. Merely having an ancestor who is tribal or American Indian is not sufficient enough to make someone a member or citizen of a tribe. A triplex of citizenship. Being a member of a federally recognized tribe provides a unique membership status within a sovereign nation. Individual members carry a unique triplex of citizenship. First, of the federally recognized tribe that they are enrolled in, as of 1924, a citizen of the United States, and today they are citizens of the state in which they are domiciled. Are tribal peoples considered a minority? Tribal peoples in the United States are frequently misclassified as a racial minority. However, Native American or American Indian are not strictly racial categories. Tribal membership differs from a racial minority group because it requires membership, and that membership is unique and recognized by law as a distinct legal, historical, and political relationship with the federal government. 2 Supreme Court cases affirm tribal membership as a political designation, not a racial one. What is self-determination? Self-determination is the ability of a tribe to assert control over its own affairs. Self-determination includes a tribe's right to freely determine their political status and the right to freely pursue their distinct economic, social, and cultural development. Over the years, several acts of Congress have modified the nation-to-nation relationship between tribes and the government. We are currently in the era of the self-determination. What does this mean? Self-determination is a federal government policy that's codified in federal law. This was developed by President Nixon in consultation with tribal leaders. A few examples of that are the Indian Self-Determination and Education Assistance Act of 1975, which allows tribes to contract with the Bureau of Indian Affairs and the Indian Health Service to operate programs including health care, law enforcement, education, and social service programs. The Indian Child Welfare Act of 1978 gives tribes and Indian families substantial protections against the removal of Indian children from their homes by state agencies and state courts. The Indian Gaming Regulatory Act of 1988 confirms the authority of Indian tribes to engage in gaming and promote economic development. The Indian Arts and Crafts Act of 1990 prohibits goods from being labeled as authentic Indian made unless they are made by an enrolled member of a federally recognized tribe and permits a recovery mechanism for damages. Also in 1990, Congress passed the Native American Graves and Repatriation Act, which creates a mechanism for tribes to recover religious and cultural items stored in museums and protects any human remains or artifacts found in the future on federal or tribal land. In 2013 and again in 2022, Congress amended the Violence Against Women Act and restored to Indian tribes the authority to prosecute non-Indians who commit certain crimes of violence against Native American women and children on Indian reservations. For decades now, Congress has promoted greater tribal autonomy within a framework of a government-to-government relationship. So too have U.S. presidents, and of relevance to our discussion today, President Clinton issued Executive Order 13175, still in effect, that requires all federal agencies to relate to Indian tribes on a government-to-government basis, respectful of tribal sovereignty. In 2000, Clinton further ordered federal agencies to work to protect tribal trust resources and Indian treaty and other rights. President Obama notably issued a memorandum on uniform standards for tribal consultation, requiring agencies from the outset of deliberations to engage in meaningful consultation with tribal governments. President Biden issued a presidential memorandum, Tribal Consultation and Strengthening Nation-to-Nation Relationships with Tribal Nations, in January of 2021, and Executive Order 14112, reforming federal funding and support for tribal nations to better embrace our trust responsibilities and promote the next era of self-determination, and that was issued in December of 2023. I believe it was stated that you may have the full text of some of these documents in your packet today. Otherwise, they can be found on the KNAA website. Strengthening tribal relations in Kansas. Just as this committee here in the state of Kansas is established, both the United States House and Senate have established specific legislation committees that work on tribal issues. In the U.S. Senate is the Indian Affairs Committee, and in the U.S. House is the Subcommittee on Native American and Insular Affairs of the House Resource Committee. Jurisdiction in Kansas. Tribes are quasi-sovereign entities that enjoy all the sovereign powers that are not divested by Congress. Tribes in Kansas continue to exercise inherent sovereignty on their lands and reservations, which includes a fundamental right to uphold tribal laws within their jurisdiction. On reservation, the type of crime and what type of land the violation occurs on determines who has jurisdiction over that crime. Civil regulatory jurisdiction. Courts have reaffirmed numerous times that tribes have civil regulatory jurisdiction on their lands within their reservation. Tribal jurisdiction remains an intricate subject that's constantly evolving as decisions in court cases are rendered. Tribal jurisdiction over tribal members. Each tribe is said to retain its original or inherent jurisdiction, except if the jurisdiction has, one, been relinquished or ceded by a tribe itself through a treaty or other agreement, expressly abrogated or taken away by Congress, deemed by the judiciary to have been implicitly lost by virtue of a tribe's historical circumstances and contemporary status. Generally speaking, tribes retain civil jurisdiction over tribal members within the reservation boundaries. Tribal jurisdiction over non-members. Under the framework found in the 1980 Supreme Court case Montana versus the United States, there is said to be, absent express authorization by federal statute or treaty, a presumption against tribal civil jurisdiction over non-members. The presumption applies to regulation, taxation, or adjudication of non-member conduct, regardless of whether that conduct took place on tribal, Indian-owned, or non-Indian-owned lands within a reservation. Tribal jurisdiction over non-Indians. The tribe will have jurisdiction over non-member conduct only if it is shown that either the conduct arises out of a consensual relationship with the tribe or its members through commercial dealing, contracts, leases, or other arrangements, or the conduct threatens or has some direct effect on the political integrity and economic security or health or welfare of the tribe. As far as criminal jurisdiction goes, in 1885, Congress passed the Major Crimes Act, which gives the federal government exclusive jurisdiction to prosecute crimes that occur within Indian country by or against Indians for 7 major crimes. The Kansas Act of 1940 applies only to lands and tribes here in Kansas. The act, passed by the United States Congress, exercising its power under the Indian Commerce Clause, states that jurisdiction is conferred to the state of Kansas over offenses committed by or against Indians on Indian reservations, including trust or restricted allotments within the state of Kansas, to the same extent as the courts have jurisdiction over offenses committed elsewhere in the state in accordance with state law. In summary, it authorizes the state of Kansas to exercise concurrent jurisdiction in offenses addressed by federal law. The Kansas Act was initially passed to address the jurisdictional gap caused by a lack of tribal law enforcement and judicial systems. Circumstances have changed since 1940 here in Kansas, and all 4 tribes have addressed that jurisdictional gap that once existed. The Double Jeopardy Clause in the Fifth Amendment of the United States Constitution guarantees no citizen can be tried for the same crime twice, but this is not, in fact, the case as it applies to tribal members in Kansas. Tribal members, as a result of the Kansas Act, are subjected to 3 layers of jurisdiction and can be prosecuted for the same crime 3 times by the federal, state, and tribal authorities. Changes in the Kansas tribal judicial systems. Today, all 4 tribes have tribal law and order codes, tribal court systems, tribal law enforcement. And in Kansas, as of 2007, tribal law enforcement officers employed by a tribe can now exercise the same authority as state officers within the external boundaries of the reservation. Tribal law enforcement in Kansas, all 4 tribes have trained and certified tribal law enforcement officers. All tribal officers attend state and federal law enforcement academies, and when training is complete, tribal officers become certified, deputized law enforcement officers like other law enforcement officers across the country. That's the end of my presentation. I thank you for the opportunity to present here today, and I stand for questions now.
Very good. Thank you for that. That was interesting, to say the least. Committee questions? Representative McCullough.
Thank you for your presentation. You referenced when you first started that you could probably answer some of the questions. I was wondering if one of them was like.
Yes. So just to reinstate that question, you wanted to know, if I understood correctly, on the federal acknowledgement process, can a group that's seeking state recognition bypass the federal recognition process? Is that, I'm sorry if I misunderstood.
Well, it can be confusing. So let me start off with a little introduction. So the chairman referenced, I'm surprised we have no Kansas laws. Well, I think the reason we don't have any Kansas laws is because we shouldn't be involved in tribal activity of indigenous people. You guys have your own police department, you have your own court system. And so I asked the question about, because I received the same call from this lady about the new tribal group that she wanted to introduce, was trying to get approval to. And so I'll get to my question. And so, you know, it's kind of like getting the toe in the door. There's already an established group with the tribal council. They should be the ones that govern and make decisions for anything that affects their tribe. This is my feeling. The state should be here to help and assist in any ways that is needed for the tribes, but shouldn't get involved in their process or their government, especially if it's not, there's no illegal activities going on. And so I feel that that's a protected entity, and once you start allowing groups to be introduced, it doesn't stop. And then everything that's established that creates this solid foundation, it starts to crack. then it turns into a lot of division and a lot of cell building, and it just doesn't work. So I asked that question because I feel the established group, being there's no Kansas state law, and federally, you can be recognized, and all the tribes in Kansas are recognized by the federal government. So I asked that question because I feel that the tribal council should make their own decisions on what governs indigenous people. And so my question is, do they have the authority to be able to do that, being that there's no state law? The feds can recognize anybody they want. The tribes of Kansas, there are 4 tribes, right?
Correct.
The tribes of Kansas should make their own decisions for who's accepted or who's not accepted within their tribal group. That's my feelings, but I asked the question, legally, is that correct?
Oh, yes, yes, definitely. Within a tribe, in the tribal nation, the Constitution spells out that the elected leadership, again, in my presentation, I referred to, acts as both the legislative and the executive bodies of the tribe. They do set the laws and policies as it pertains to their membership particularly. And in each tribal constitution, there's a membership provision which spells out, like the federal acknowledgement process, what is required to become a member of that federally recognized tribe. Not just the 4 tribes in Kansas here, every 574 tribe constitution across the United States does have a membership provision that does spell out their specific constitutionally required criteria for membership in their tribe. As far as in the state of Kansas here, yes, there has been 2 groups that have come forward and are seeking federal recognition, or excuse me, state recognition here in the state, and that's because they cannot meet the federal requirement processes to become a federally recognized tribe. And so they're coming here to the state now wanting the state to recognize them. They did come to my office, and my office had referred them back to the federal acknowledgement process, and that is how they disclosed the fact that they didn't want to go through that process because they tried and they couldn't meet those requirements. That is something that my office, just in respecting the inherent sovereignty of the tribes here in the state of Kansas, is clear on that response, that we will not create a policy to violate that sovereignty of the tribes here and extend a recognition process outside of the federal recognition process that's already established by federal law. And so there is a statement that goes out from my office to tribes that are seeking state recognition. And again, in short, it refers back to that federal acknowledgement process and provides them resources and such. But this has been a group that's continually come forward with the same request.
Well, I don't feel this legislative body should get involved in tribal council activities. The other thing is that she was requesting a vote to approve them as a tribe within the state of Kansas. I don't think we should be involved in that neither. My recommendation was her to contact the tribal council, and she'd have to work it through that process. And no one sitting up here should draft any legislation that comes in and impedes that upon the tribal council. That's been the problem for years. There's a lot of stuff that's involved in that: lineage, heritage, culture, the way we live. We live differently than other people. We have different ways. And so all those things need to be looked at, and they can't be looked at from people outside the group that don't live within the environment of indigenous people. And so I would say, and I say this to my colleagues, I will definitely fight tooth and nail if we try to draft legislation that approves something like that without the tribal council's approval.
Also, that does create certain responsibilities and liabilities for the state of Kansas, because that comes with jurisdiction and lands and other rights. And so it's a very complicated subject matter, but again, we have not even entertained that because we believe that there is a federal acknowledgement process that is in place, that is well established, and that that is the place that it needs to go. Tribes are on the same kind of government-to-government relationship with the federal government, so that relationship lies there. It doesn't rely within the state here. And so we respectfully just, again, defer to that process and try to uphold that.
I don't disagree with that. And I would tell you, and you recognize some of the faces, I don't recognize the names. Once the state starts getting involved in tribal activity and tribal council activity, where does it stop? We're here to help and assist. The tribal council is put together to make their laws and decisions within the indigenous folks. And so I just want to, I'm not being repetitive, I want to make sure that it's understood that the state should not be involved in trying to add groups or other tribes without the tribal council's approval. And I feel that's their authority. I have one other question, Mr. Chair. So do you have a staff in your office, or are you the only one?
No, I'm the only one.
So here's my other gripe, is that African Americans, Latino Americans, Native Americans, there's only one director and that's it. There's a lot of things that could be done if there was an assistant. And I sit on appropriations. If I sit on it next year, I'm looking at another FTE for those positions. One to answer the phone, one to set up appointments, one so that it allows you to go out and do outreach, one that creates a clearinghouse where information can get out throughout the state to indigenous people what services are available. And you just can't do it with one. We have one to say that we just have the department, but we need to make it more efficient. We're not even streamlined, we're below that. And I'm going to ask you this question, you don't have to answer it. How many things could you be doing with an assistant that you can't do now because you're busy being the assistant?
Well, I thank you for just recognizing that. And yes, you know, the office could do a whole lot more. The relationship between the tribes here and the state in many different capacities, I believe could be strengthened in many ways, and I always look to do that. I have worked with several secretaries since assuming this office, and a lot of that is just in sitting down and educating them about their particular subject matter. Let's say it's transportation and how that affects the tribes, what it looks like for jurisdiction and roads and other things there, how the BIA comes into play with that. And I really believe that that education component is vitally needed across state departments here, and it only helps to strengthen the relationship between the state and the tribes in many different ways. And it has been noted by several secretaries that that is greatly appreciated, and I enjoy doing that work here for the state.
Bottom line is you can do a lot more and actually help and benefit the state through these organizations, especially through the Native American Association. Well, thank you very much.
Committee, further questions? Representative Hasswood.
Thank you, Mr. Chair. I've heard sometime that there were tribal liaisons in different state agencies and departments. Is there a list of them and their contact information?
Oh, yes, yes. Yes, that is one of the things, I believe it was in 2021 that the tribes did ask the governor's office for, to provide tribal liaison contacts for each of the state agencies, and that is something that the governor's office did do. So yes, I do have a list of those tribally or appointed contacts within each of the state departments that are appointed from the governor's office, so I can get that to the committee and they can distribute that to you.
Mr. Chair, I have one more question, if I may. So I know I see you in so many different spaces. Can you touch a little bit more on different projects and committees that your office is a part of? I know you and I serve on an Indian education committee with the state school board, and I think, you know, entrepreneurship is such a big one too. I just wanted to hear a little bit more insight on what projects and other areas that you are involved in, or maybe you would like to be more involved in.
Let me just sit here and think for a minute. There's a lot of different things that I sit on. The Disability Services has a committee that looks at mental health and other things here in the state, and I sit on that committee for them. The State Historical Society has a committee that has tribal representatives as well on that to make sure that they are in compliance with the federal laws for the Native American Graves and Repatriation Act. Yes, I do serve on the education committees. Let me think, formal committees that I serve on. I would have to sit there and I could get you a list of those if I go back to them. I have them written down on my calendar. I serve in some of the committees, mainly in working groups to identify the needs and how they can strengthen that relationship and some future projects that they have. For example, the Secretary of the Parks and Wildlife just reached out to me about a project that they want to start with the tribal nations, and so it's facilitating that first meeting and identifying ways that they can do that. And that has been the same for several of the different departments with the secretaries. They're wanting to just reach out more and have an idea about how they would like to strengthen the relationship with the tribes, primarily because they don't see anything established within their department. And my office has been working since I assumed this office on the infrastructure funding here in the state of Kansas to assure that the tribes do have equal access to that funding. Primarily, federal funding comes down directly to the tribes, but the way that the bill funding happened, it goes through the states, and the tribes have to compete for those same dollars along with other state government entities. And so some of that funding has specific requirements that have certain set-asides for tribes. And so just facilitating all of those different opportunities for water, energy, transportation, and broadband, and attending some of those listening sessions so that I can make sure that I'm getting the tribes the accurate information that they need to have. Does consume a lot of my time, but again, it's a historic opportunity for us to improve the infrastructure overall here in the state of Kansas, and so I believe it's very important for us to take advantage of that opportunity.
Thank you. I know there's probably many more that are on your calendar, so just want to say thank you so much for your time and effort, and I hope the legislature would consider expanding your office and providing more funding, not only to that, but to other offices as well for our folks, minority folks.
Thank you.
Committee, further questions? Justin?
Can you hear me okay?
Yeah.
Jancita, thank you for that excellent presentation. I just wanted to touch on, make sure I'm understanding, I think, a really important point that you made, that the sovereignty of some of the tribal governments predates that of even the colonial governments. So when we're talking about federal recognition, that's different than a recognition of sovereignty. The federal recognition is just the federal requirements for recognizing that the tribe meets those criteria you discussed. Do you recall in that recognition process, is there any requirement that there be state recognition?
No, that is a misconception, and what one of the groups have come forward stating that the reason that they can't become federally recognized is because they don't have the approval of the governor here to get state recognized, and that is in no way factual. I'm absolutely certain of that. There is no requirement, and many times there is no reason for a federally recognized tribe to become state recognized as well, because that is an inherent right of theirs, and they're already recognized by the federal sovereign. And so the federal requirement process was started in 1978. Again, 99% of tribes that have the federal recognition have it established through a treaty. There was a few tribes that for whatever reason fell through the cracks there, and in order for that to be addressed, they created this federal acknowledgement process. And again, it's very well laid out. The requirements are very well defined in there. And tribes just have to go through that process and provide all of these documents and things to show that continuous relationship throughout history there. And so, yes, it's not used very much because, again, most of the tribes do have that recognition that's established by treaties that are very, very old.
So is it, I think you said this in your answer, I just want to make sure I understand. So is the state recognition, it's not going to give them any powers under the federal statutes for the federally recognized? Stated another way, state recognition is not going to be a substitute for getting federal recognition that helps with all these laws.
No, because even if they're state recognized, they don't qualify for the federal funding. They don't carry the same jurisdictional sovereignty that a federal sovereign does. They are not recognized as a sovereign outside of the state that they're in. And the federal government, again, only if you meet their process and you're on that official list that is published in the Federal Register in January of every year, the federal government doesn't recognize that or any of those rights that a sovereign is able to exercise are not recognized outside of the state that they're in. And even if there is in the state, it should be well defined as to what does that mean? What are those rights and responsibilities? And again, that opens up a whole another area that is undeveloped, and it's something that can't just be decided this year with no kind of idea of what that really means and what the implications of those are. And so, again, I suggest that you all defer back to the federal process on that. That is well established there.
Senator Alley.
Thank you. I think you're explaining this, so I'm understanding that on the KLRD document, which we received on page 11 and 12, it has 30-some names of tribal affiliations that are not recognized federally. I think that's what I'm hearing.
No, that they are included. Any person who's including any federally recognized tribe containing one or more of the references to tribal affiliations with the tribe's name. I just need to provide a quick 30-second history lesson about this. The tribes at one time, especially when they signed treaties, again, treaty making ceased in 1871, they were one particular tribe and as just one sovereign tribe. And when the government attempted to start removing them for different reasoning, they broke up the tribe into different fractionations. And so today, for example, the Kickapoo tribe, there is one band of Kickapoo that are here in Kansas that are federally recognized, but there are 3 other bands of Kickapoo that exist. They are all federally recognized by the government as their own sovereign government. The Potawatomi have 7 different fractionations of Potawatomi. Only one resides here in the state of Kansas, but they were removed here from the Great Lakes area. The Iowa tribe of Kansas, it says of Kansas and Nebraska, they are a fractionation. There's an Iowa tribe that exists in the state of Oklahoma and one that exists in the state of Iowa. And so those are just a couple examples of why this list talks about containing one or more references to the following affiliations, because whether it says the Forest County Potawatomis of Wisconsin or the Prairie Band Potawatomis of Kansas, if the Potawatomi is affiliated within that name, and usually the legal name for the tribe includes the state that the federal government removed them to. So that's why, again, the Sac and Fox are the Sac and Fox of Missouri and Kansas is their legal full name.
Thank you for that. That helps a little bit with my question, but for instance, I'm just going to choose one name here, the Cherokee tribe.
Okay.
Are they not a federally recognized tribe in Kansas? Federally?
No, they are not a federally recognized tribe here in the state of Kansas. They have 2 federally recognized tribes in Oklahoma and 1 in North Carolina. In reference to this particular law, it not only recognized the 4 tribes that were here in Kansas, it recognized the states that were indigenous to Kansas before the federal government removed them. Quickly at a time when removal was happening, it was the policy of the federal government to remove all tribes west of the Mississippi. That's before they realized tribes existed across the whole United States. So they created this melting pot area of where they were going to remove all of these tribes. And this was before Kansas statehood. And so that area that they identified became what is now Kansas and Oklahoma, and it was referred to as Indian Territory. So as they started removing all of these tribes to this particular area, unbeknownst to them, we had our own issues here in the state of Kansas, and Bleeding Kansas broke out. And so there was this war-like area on the front end of that land, and so the federal government had a duty to protect those tribes, and so it thought it best to remove those tribes, again, some for the 2nd or 3rd time from land that it resettled on, and remove them from what is now the state of Kansas further south into their territory that they identified as Indian Territory to what is now the state of Oklahoma. That's why there's 36 tribes that are domiciled within the state of Oklahoma today. So when this bill was passed here for education, it included not only the 4 resident tribes of Kansas today, but it recognized those tribes, those original tribes that were here at the time when the institutions were first founded and then removed to Oklahoma, but they are indigenous to the area, and so that's why they are listed in this list as well, but are not recognized tribes in the state of Kansas, but they are federally recognized, a majority of them being in the state of Oklahoma today.
Thank you very much.
Any further questions? Representative McCullough.
Thank you, Mr. Chair. I'll be quick. I'm going to take a couple steps back to Justin's questions to you. So I get the sense, and I may be wrong, Justin, but I've been around a while, that if he feels the governor's office could make that approval of this additional tribe, would that be politically correct? And the question kind of went around saying that, but it wouldn't affect you guys. And so sometimes in politics, we want to be politically correct and we want to make everybody happy and not be the one in the middle of it. So I could see that question leaning to, well, what about if the governor does the recommendation? I'm not saying this is it, but this is the way I read it. Makes the recommendation, but that you guys are still in control. Well, I think that would be impolitically correct because it would be going against the existing tribal council. So I don't know if that's where you were going with that, Justin, to try to find the happy medium or not, but there's no happy medium. It's one or the other. And so once we start doing that, and there's no authority to do it, we're going to have problems. So I just wanted to make that comment because that's what I read from that. I felt that you were feeling around the room to see, well, you know, what happens if we make that recommendation? We don't make them mad, you know, and we let them know that it's not going to affect the tribal council. We don't make them mad, but you do.
In the last legislative session when you guys had the hearing this year, I know 2 of the 4 tribal chairmen did specifically in their testimony ask this tribe to not entertain any group that would come forward trying to circumvent the federal recognition process and come to this committee to seek state recognition. The tribes also asked to meet with the governor's office and did extend that same concern about that particular subject matter, and I'll defer to them if they want to speak further about that.
No, I wasn't trying to put you on the spot, and I could be misreading this completely. But I want to make it very clear that I don't like that idea. And so, because it still takes away, if she doesn't, she has authority to do, the governor has authority to do whatever she wants. But if that authority isn't in law, I think it takes away from the authority of the tribe. I think the state needs to stay out of tribal council business. Help and assist. That should be it.
Hang on just a minute. So I want to be clear that this is just an informational hearing for all of this. We're not, there is no, effect, or we're not trying to do anything except educate ourselves on how to make Kansas and tribal relations better. So whatever, John, I appreciate where you're coming from, but this isn't a conspiracy theory type of deal here. So I just want to make sure.
I agree with you.
Okay.
But I also know that if we don't speak up and show the lay of the land and the foundation right away, then conspiracy theories can develop.
Well, I appreciate that, but there is none. Justin?
I appreciate Rep. Alcala, the comment. I was approaching it from the legal lane and not a policy perception. Really just trying to get at, I'm not sure, what is the legal implication of state recognition, if there is one? And I think the answer I seem to be getting from you is like, in terms of federal recognition, recognizing on the state level doesn't appear to have any legal impact. And so I don't know, perhaps I can't speculate as to why there's no process for it, but I was just trying to get the lay of the land of like legally, what would it even mean for the state recognition? And what I'm hearing is it doesn't appear that it would have any impact, but I will defer to Jancita and Russ and Chairman Rupnick on that.
Representative Tarwater.
Thank you, Mr. Chairman, and thank you for being here today. I want to talk about your 2025 initiatives. You say reinstate the Native American Law Symposium. Can you tell me what that is, when it was dissolved, and why it was dissolved?
I am doing some research on that now. I'm not sure if any of the tribes here that have been around longer than me can provide you some of those dates, some definitive dates on that. But from what I understand, it had existed for about 10 years. It had happened maybe about 2017 the last time, or 2000 or so. And what it was, I believe from the history that I saw, that this committee had asked for some additional information about tribal subject matter. And so the tribes had got together and coordinated this Native American Law Symposium. From what I understand, the top subject matter that was requested from not only this committee, but from judges and others in the area was on the Indian Child Welfare Act. And so they brought in legal experts from around the nation to speak on these subject matters, as well as others that were requested. They did provide CLEs. And so there were many lawyers and judges from across the state of Kansas that did attend these events. And each tribe hosted it at various times in its history. And it was just a good also relationship building to get some of the legal people and judges and others in the area that would have not visited the reservations prior to that there physically, just to experience where the tribes were, to learn a little bit more about them, and then attend this and receive their CLEs.
Any further questions? I have just a couple here. So it was mentioned in here, non-member and member. So is that a tribe member or is that an individual?
In the presentation?
Yeah.
Yeah, a member being, if you're a member of a federally recognized tribe, non-member being non-member, just not an enrolled member of some federally recognized tribe.
All right, very good. On this one page here, I think it's 36, so you're talking about the double jeopardy clause of the Fifth Amendment, but tribal members are subjected to 3 layers.
Correct.
Does that happen?
Yes. I'll defer to the tribes to give some specific instances, but yes, that is, and again, that only applies to tribal members here in the state of Kansas. Nowhere else in the country does this apply, but here in Kansas, and it's a result of the Kansas Act.
Staff, could we get some more information on that, please? That's curious. And then just a final question. So your budget, you're through the governor's office?
Correct.
Okay.
Yes.
And so any budget increase or anything like that would be through, if you wanted more staff or anything like that, you would ask for that through the governor's office?
Yes, correct.
Very good, thank you. Committee, further questions? Thank you very much.
Okay, thank you for having me.
Very informative. What are we looking at here? Okay, Kayla? Kayla, thank you very much for being here.
Okay, good morning, Chairman and committee members. My name's Kayla Loomis. I'm the Executive Director of the Kansas State Gaming Agency, and I appreciate this opportunity to be here and speak in front of you. So I'm going to do the same thing as she did, is kind of go through this written testimony I provided, and then if you have any questions, and I'll also expand on it to describe some things. But first of all, I'd like to thank Jancita for the historical and educational information you gave. That was very, very interesting. So to start with, we have, they've described the 4 tribes here, and there's 4 casinos that are related to them. So it's a White Cloud tribe, or White Cloud Casino up in the Iowa tribe. And then there's the Golden Eagle, which is a Kickapoo tribe. The Sac and Fox have their own casino, Sac and Fox. And then the Prairie Band tribe also has their Prairie Band Casino and Resort. So those are the 4 casinos we look at. And to understand that, those are Class 3 casinos, and I won't go into great detail with this, but Class 3 are when you're betting against the house and they're Las Vegas-style casinos. There's also Class 2 casinos, which we have nothing to do with, and the tribes also have Class 2 gaming on their reservations. Their Tribal Gaming Commission is completely regulating that. We have nothing to do with it unless they ask us occasionally to do a background or something because of our resources. So that also, to throw that in there, the Wyandotte Nation casinos that are the 7th Street in Kansas City and the one in Park City, we have nothing to do with. Those are Class 2 casinos. And I believe that's some of the tribes that they've been talking about that are not under our regulation. So to kind of understand that. Now also with the Senate Bill 84 that was just passed on the sports wagering, that is also something that comes under Class 3. And right now the Prairie Band has that, and it's established through a new compact. I believe there's 2 others that are in the process possibly of negotiating that, but that does not go through us, that goes through the governor's office. So we just help in any way we can on that process. And then through this, just so you know our mission statement, and everything is established through IGRA, and it goes back to that process. So our mission statement is, the agency has a mission and goal which includes protecting the integrity of gaming by ensuring compliance with the tribal state compacts, the Tribal Gaming Oversight Act, and any applicable federal and state laws that apply. Our agency right now is made up of an enforcement unit, which is a law enforcement unit, and then also a special investigations unit, which do a lot of the background, and I'll go into that a little later. But we also have technical and support staff. At this point in time, we actually have 15 FTEs, but 3 of those positions are not filled. 2 are unfunded, and 1 is a funded one, with the anticipation if there is any other expansion on sports wagering. So at this time, we've kept our numbers down as far as staffing. So just to understand that, so our enforcement agents are the criminal side and do most of the investigations, but our special investigators are actually responsible for conducting background investigations on all employees with the gaming operations at each casino, and that's established through the compacts. We're also responsible for conducting certain background investigations on vendors that spend a certain amount of money with the tribe in a year. So we will conduct those too. And again, occasionally they'll ask us to do the Class 2 ones to assist them because of our resources. So we will do those if they ask. All the licensing actually of the gaming vendors and employees is actually done through the Tribal Gaming Commission. We only conduct the background investigations. Then we will submit a report to them with a recommendation and let the Tribal Gaming Commissions decide on the licensing. There is some sections in the compact that are very clear that there are some disqualifiers that we will at some point, we might either suggest something to them or we will ask for a denial based on those sections in the compact. So in these backgrounds, not to get into great detail, but we do criminal investigations. We have those abilities to get KBI and FBI reports. We will also conduct anything else that's required that is also put in the compact. There are appendices to the compact that actually lay out what we need to look at on each level of background and on vendors. So we will get all that information that's possible and provide that. As far as our enforcement agents, our agents actually will conduct compliance investigations at the casinos. We do inspections of the electronic gaming devices, the slot machines. We also monitor the gaming activity. And again, with the criminal investigations at this point, if it is a gaming crime, we will get more involved. But we do, since the tribes all have their own police departments now, we will defer to them a lot. We will offer our expertise with the gaming crimes and help in any way we can, or if the tribal police departments ask us for our assistance, we'll be happy to help in any way on those, in anything that's happening at the casinos. So just to kind of explain some things, we have a relationship with the Kansas Racing and Gaming Commission, and that was established a long time ago as a sister agency through them. So we do have to report to that commission for 3 items. And the 3 items are our budget. We have to present that, which is coming up Friday. We'll present that to them. And then I'll go into how our budget's set too in just a little bit. So we'll do that with them. If there is any major changes in our staffing or what our employees need to do to qualify for staffing, we will have to go through them. And then also if there would be a dispute resolution, we would have to also go through the Kansas Racing and Gaming Commission to get that. That is the only 3 items we go to them for. And everything else is on the executive director of the agency to decide. So those are kind of established things. Again, every September we go ahead and provide the Kansas Racing and Gaming Commission a budget review. So KRGC regulates all the state-owned casinos, and we are the agency that has only oversight over the tribal casinos, just to make that clear. So we have nothing to do with the state casinos. They have nothing to do with the tribal casinos. And then our funding and our budget is based on a section in the compact that requires our agency, myself, to establish a budget that's acceptable for what we need to provide to meet the compacts and any other laws and stuff. So we will provide that budget to them. And the way the process, we're a little different as an agency because of the way the compact sets it up. By the end of July, before August 1st, I have to present a budget to the tribal councils. And we'll put that together with information on our inspections and some other information on what we're doing, present it to the tribal councils. They have the full month of August to look at that budget and decide if there's anything they need to question or ask about or if they want to dispute something. If they have not disputed that, by September 1st, they have 20 days to make their first assessment payments to us. So there's 3 assessment times. Once that's established, the budget's good through the full fiscal year cycle. So they will make those payments on September 21st or before, and then it would be also January 1st and April 1st. That's the way we're funded. like I said, a little different than most agencies. We also still have to go through the state legislative process with the budget and present too. So we do all those required elements. As far as kind of talking about specifics, and I can't really get into a lot of specifics because everything, as you've heard, is proprietary and sovereign information to the tribes. So at this point in time, everything that the way the compacts establish it is, the only people that are allowed to have the information we provide or share, and if we do reports or anything, we always share it with the tribal gaming commissions. They are their primary regulator. They do all the licensing, and so we share back and forth. The only established agencies that can share that is the Tribal Gaming Commission, our agency, and the KBI, because originally before this agency was established, the KBI was the one that took up this charge and was actually providing the background investigations until this agency was established. So that it's kind of a brief thing. I guess I would stand for any questions, because I don't really know exactly what specific information you need to know about our agency, but I'd be happy to stand and answer any questions.
Did you have a question? No. So when, just a quick one, when was the changeover between the KBI and?
Yeah, it was in the late 90s when everything was starting to get established and all the casinos got up and running, and then the agency came aboard in the late 90s. Yeah, and I'll just give you a brief explanation of who I am too. So my background is law enforcement, and I started with this agency actually in 2006 as an agent and went through the process. And then I did work for the Kansas Racing and Gaming Commission for a brief time doing corporate investigations. At that time, I was brought back by the former executive director as a director at the Kansas State Gaming Agency. And then in late 2018, I was appointed as the executive director, and I've been serving in that position since.
Any questions? Or Senator Alley?
Thank you. Thank you. Your agency, does it have anything to do with the historic horse racing?
No, that is Kansas Racing and Gaming Commission. That's all theirs, so we have nothing to do with it.
If one of the tribes wanted to have historic horse racing on their reservation, would that be under your?
There are some specific things in the compact that are not allowed, and some of that stuff is not allowed. Just like at one point, sports wagering was not allowed specific in the compacts, but with the renegotiation of the compacts now, it was. So there are things that they cannot do by compact at this time. Now, could they go back and possibly renegotiate? That could possibly happen, and then it would really depend on how the compacts were rewritten if they gave us the authority to do that. So that would be up to the tribal councils and the governor's office to establish that.
Representative Hasswood.
Thank you, Mr. Chair. You mentioned the Tribal Gaming Commission. Who's on that? What's the makeup of that?
Well, each tribe has a tribal gaming commission that, and there's some different ways. 3 of them, they are appointed by their tribal councils, and then actually the Prairie Band, they're elected. So there's a different process depending on which tribal gaming commission you're talking about. And they have different sizes, I mean, from membership wise. So that's done by the tribal councils, the governments.
And another clarifying question. You said that you present a budget to the tribal council. Is that the budget that is then presented to the legislature? What's in that budget?
Yes, exactly. It's our full budget, and it would have everything to do with staffing and any expenses and anything else that we would need to run our agency through that year. There might be a little change just because you know how sometimes when you get to benefits and stuff, some things change because we are all state employees. So that could differ just a little bit, but not much.
And does your office have like a tribal gaming expertise, or is it just kind of everyone in your office knows about tribal gaming?
It's more that, and most of, especially at this point in time, which we are very fortunate, most of our staff have been around a long time, so they do have the expertise because of the historical knowledge, and again, then we send them to training on all kinds of different areas, from law enforcement to gaming issues.
Thank you.
You're welcome.
Any further questions? Justin.
Director Loomis, thank you. I noted in your materials you say KRGC regulates the state-owned casinos, and KSGA has oversight of the compacted tribal casinos. Maybe elaborate a little bit on that distinction between your agency has oversight but not regulatory authority?
Right. So the way the compacts are written, the tribal gaming commissions have been established as the primary regulator. So, and those go through the tribal council. So they are the primary regulators. We have oversight over the Tribal Oversight Act, the Gaming Act there. And so we concur with things, and we work with the tribal gaming commissions to follow the compacts, establish laws, and everything else. So we are not the primary regulator, we're a secondary regulator.
Any further questions? Seeing none, thank you. Now are you going to go on to the budget then? Oh, you're going to do the budget. Okay.
Thank you.
Thank you very much.
Mr. Chair, members of the committee, KLRD also provided, along with the State Gaming Agency's testimony, a copy of the budget analysis from the 2024 session. And if you have any questions on that, I can contact our fiscal analyst for the agency and get back to you.
Thank you for that. Committee, you want to take a brief minute to go over this? If you have any questions, or you want to move on? Going once? All right, we'll move on then. If you do have any questions, certainly get with staff or any clarifications or anything like that, and we'll get some folks some budget analysis in here. Okay, well, we've been moving right along. It looks like we're going to adjourn. Girls, do you have anything else for us until after lunch? Anybody have anything else before we go to lunch? Okay, we are adjourned till, oh yeah, we're recessed until 1. Okay? All right, see you guys back here at 1. Thank everybody for coming. Staff, thank you for coming back. Thank you, committee members, for coming back. Appreciate all of you being here today. Committee members, if you would sign your sheets and get them to me, that way I can get these all turned in. That would be great. Okay. Next, we're up for a presentation on tribal water rights. Burke? Burke, welcome to committee.
You've asked me to summarize one of the more complicated subjects in natural resources law in about an hour. I think it's kind of neat that someone photocopied 2 pages of Felix Cohen's Federal Indian Law treatise. That's a big book. It's one of the hardest areas of law is federal Indian law. I'm going to limit my presentation today to how recognized Indian tribes, and that's a term of art in the law. We call recognized tribes and other tribes Indian tribes, and that's always been the case. What their rights are to water across the nation. This is a long-standing body of law that starts in the 19th century. So what I would like to do today is operate the screen. Might need one of you to advance it for me. Okay, great. I just need to know because I've got to go. All right, what I'd like to do today is talk about Western water law. By that I mean mostly state law, which starts to emerge in the middle of the 19th century, and talk about the issue of tribal sovereignty. It's the sovereignty of a tribe that gives it the rights it has under federal law. And this creates a problem. You have an entire regime for state law water rights that starting in the middle of the 20th century starts to collide with a federal regime for tribal water rights. How do you make sense legally of this collision? And then I'll give you some examples from across the West, talking about Montana, talking about the one settlement we've achieved here in Kansas, and then talking about Arizona. And full disclosure, I am now a professor at Washburn. I represented the state. I was the counsel of record representing Kansas in the reserved water rights settlement with the Kickapoo tribe. So I'll be summarizing that settlement briefly. I'm happy to take questions. So next slide, please. Here you have 6 weeks of my water law class in one slide. It's property law, okay? A water right is a property right. And as property, most property law is within the province of state law. So a water right is not an ownership of the water itself. It is a right to use water. It's what you call a usufructuary right. And you only have a right to use water if you can establish that you're putting that water to beneficial use. If you don't put that water to beneficial use, then under most state regimes, you can be vulnerable to losing that right. More importantly for our purposes, the Western water right is severable. By that I mean you can take the water right where it is. Let's say you are diverting water from a stream in the mountains of Colorado, and you own a farm or a ranch somewhere in the mountains of Colorado. You can establish a water right separate from that farm and use the water to irrigate your farm, let's say. But later on, you can sell that water right, and that water right can be moved to supply, let's say, a city in the Denver area. In the east, the eastern part of the United States, basically east of the Missouri River, water rights cannot be easily severed from the land. But in Kansas, they can be. So we define a water right under state law as severable. And if you drive around any of the big cities of the West, you will see water supplies coming in from somewhere else. I've just mentioned 3 really prominent ones. Denver gets a lot of its water from the western slope. Albuquerque gets a lot of its water from the San Juan River in the Colorado River Basin. Los Angeles gets a lot of its water from the Owens River in the eastern Sierra, across the Sierra Nevada mountains. Starting around the 1880s, the 1890s, states started to put all of the water rights, regulatory work, and property work under a state official. Here in Kansas, we call that person the chief engineer. Other states are called the state engineer. And the state engineer has 2 basic jobs. The first job is to put water to beneficial use. If someone applies to obtain a water right and there's water available and it won't hurt other water users, then generally the state has the duty to put that water, to grant that water right. We've done a great job of that. We've granted about 50,000 water rights in the state of Kansas. The other job of the chief engineer is to administer water rights. That is, follow the first in time, first in right rule. If all of you are water right holders on a stream, members of the committee, and from left to right, Kessler has the senior water right, Bowers has the junior water right. And let's say we're all pulling water off the Kansas River to irrigate our farms. Very simple facts. Well, the Kansas River level starts going down. There's not enough water to satisfy all of your rights. We don't share the shortage. Let's say there's 90% water, 100% rights, we have a 10% deficit. You don't all take a 10% cut. Bowers is off. She's totally cut off until the 9 of you are satisfied. Does it get worse? Well then, Haswood's cut off until the stream recovers its flow. And the logic behind that is that in the West, if we shared the shortage, none of us would have enough water to bring the crops to harvest because we live in a dry part of the country. Okay, that raises, next slide please. However, there are real problems with this, and there are problems that we have recognized for a long time. These are not new discoveries, which is why I'm citing Elwood Mead, after whom Lake Mead is named. People usually claim more water than they need. Now, in the 19th century, this was the result of not having good measuring devices, people being conservative, claiming a lot more water. However, the second problem is the bigger problem. It is easier to grant a water right, people want to have water rights, than it is to shut people off. There are often political and other obstacles to doing the scenario I just described. There's not enough water. Bowers is going to get shut off. There are problems across the West. I could go into some of them if I had more time. But a classic example is New Mexico. New Mexico has proven to be very hesitant to actually apply the prior appropriation doctrine in practice. And Kansas, we're seeing signs of that too. Okay, next slide, please. Kansas water law is a statutory body of law. It was passed in 1945. It was substantially amended in 1957. It codifies the prior appropriation doctrine. A water right is severable. It's a real property right. You have to go through the procedures of obtaining a water right set forth in statute. If you have a senior water right, you are entitled to the protections of the prior appropriation doctrine. But one of the biggest problems in Kansas is a problem that's facing other Western states, and that is we granted more water rights than there is water to supply them. There are defensible historical reasons for this. The biggest problem is that much of our largest water supply, the High Plains Aquifer, is not renewable. So for a time, in the 1950s and the 1960s and the early 1970s, there was enough water to grant new water rights. But now, in many regions of Kansas, we have 20 times as many water rights claims as we do water. Next slide, please. And so this is the slide that should haunt your dreams. I'm sure you've seen it before. This is a groundwater atlas. And for a second, just linger on how cool it is that we have this. We have this because Kansas has the best water rights data in the world. Every owner of a water right has to report their water use. 98.8% of the people do. Secondly, the Kansas Geological Survey, which produced this map, has a network of measuring and monitoring wells across the state. And so you'll see by this map, this is western Kansas. This is not where we have any tribal reservations. And I think that's significant. If the Comanche had remained on their ancestral lands, this entire map would probably be Comanche territory, or at least the southwest part of it, okay? Where the colors are darkest, the situation is the most bleak. So if you are in west central Kansas, Scott City, you'll see that over 60% of the aquifer is gone. And we only started pumping from this really on a large scale in the 1950s. As you go east, that part of the High Plains aquifer, the equus beds, is more connected to surface streams. It's more renewable. But in western Kansas, this is one of the reasons we have more water rights than we do water. Next slide, please. Now, what groundwater pumping does is it depletes stream flows. Groundwater and surface water are connected. There are certain states, and we should be glad we don't live in those, they're called Nebraska, Arizona, and California, which have different rules for groundwater than they do for surface water. We don't. However, by allowing all of this groundwater pumping, we have done two things in western and now central Kansas. We have turned what had been perennial streams that ran year-round, into ephemeral streams that only flow when there's some sort of rain event. And we've dried up a lot of streams permanently. You may think this is a western Kansas problem, which it certainly is, but it's a statewide problem, and here's why. If you look at the Smoky Hill River, that's the one with the little balloon on the left. It's an enormous river basin. It's basically the river basin between the Republican and the Arkansas River basins. It starts in eastern Colorado. It is an enormous basin. We have pumped the daylights out of that basin in both states. And so the flows in the Smoky Hill have been going down since the 1970s. The Smoky Hill joins the Republican River in Junction City, Kansas. The Republican River has been permanently depleted by upstream groundwater pumping in Nebraska and Kansas. The Smoky Hill has been permanently depleted by groundwater pumping. So the river you see to the north of here, the Kansas River, which is those two rivers, does not flow at the volumes it used to before the 1950s. Next slide. Are you sufficiently optimistic now? Yeah, okay. Now, turning to sovereignty. This is an extremely important point. When you are dealing with Native American tribes, they are sovereign. You will see this sovereignty demonstrated in their water rights. But we have three sovereigns. We have the United States, which is supreme under our federal system. Tribes are sovereign over their tribal real property. But there is a big however to this, and that is the United States acts as the trustee for the sovereign of the tribes. The state of Kansas is also a sovereign. So when you are dealing with tribal water rights claims, you are dealing with at least three sovereigns. You're dealing at least with the tribe, the state, and the United States. However, there may be more tribes, and we'll see that if you're in Arizona, if you're in California. We have 4 tribes in this state. California, Arizona have many more than that. If you have a reservation that straddles a state line, the Navajo Reservation straddles the New Mexico-Arizona border. The Iowa Reservation straddles the Kansas-Nebraska border. So these sovereigns are entitled to the powers and the respect of sovereignty. Next slide. You won't be tested on this, but I want to put this in a little perspective, okay? From time immemorial, and that is a legal term, which I will get to, until the 16th century, Kansas is the home of many tribes. And then from the 16th to the 19th centuries, you have the period of European conquest, settlement, the expulsion of tribes from the Great Lakes area in the east into the Midwest, into Kansas, and often out of Kansas, which is why the Kansas Reservation is in Oklahoma, and why the Kickapoo tribe reservation is in Kansas, but that was a Great Lakes tribe. It was pushed down here. So the history of this is not just one of eliminating a tribe, it's often one of forcible relocation. Legally, the United States deals with the tribes in 2 basic ways. The earlier way was through establishing treaties with the tribes. The other was through acts of Congress. Those are 2 different aspects of the constitutional power, right? You've got Article I power through Congress, then you have the treaty power. Starting in 1887, and this is where there are a lot of Kansas stories here, Congress decides to pass the General Allotment Act. The General Allotment Act, on its surface, was based on the premise that corporate tribal ownership of land was an obstacle to the Indian becoming civilized. And I'm using the terms that they used in the General Allotment Act. So, what the General Allotment Act allowed was for tribal land that the tribe held as a corporate body to be individually parceled out to individual members of the tribe. And those tribal members who now had individual land ownership were called allotees. And I'm going to come back to that because a reservation has many different owners. If you look at the Kickapoo Reservation, there is land owned by the tribe. There is allotment land owned by allotees, members of the tribe, who own it in fee individually. And then there is allotment land that tribal members sold to a non-Indian. So you'll have a non-Indian owning land within the boundaries of an Indian reservation. And that's because of the General Allotment Act. I will not go into these other things with such detail, but this issue of allotments is important. 1908 is a case we'll talk about. It's the landmark case granting, or the court would say recognizing, tribal water rights. Tribes obtain citizenship. Indians obtain the right to vote. In 1924, most people don't know that it wasn't until then that they could even vote. 1952, the McCarran Amendment is passed. That allows the United States to be dragged into court. You were probably familiar with the idea of sovereign immunity. Good luck suing the United States. You better have legal evidence in the form of a statute that the United States has waived its sovereign immunity. The McCarran Amendment is a waiver of sovereign immunity for the purpose of the United States coming into water rights settlements. I'll talk about that in a little bit. Starting in 1953, Congress started a decades-long policy of trying to get rid of tribes. This is called determination policy. And it was disastrous to tribes across the country. And it wasn't really until the early to mid-1980s that tribes started to recover from the termination policy. The other 2 cases I'll discuss. So because you hired a law professor and paid him nothing for this work, I'm going to go through some cases. Okay, we'll talk about 3 cases. Next slide, please. Okay, this is the big one. Winters versus United States, 1908. You have 3 tribes in the Missouri River Basin of northern Montana. The Gros Ventre, the Blackfeet, and the Assiniboine. They basically have this basin to themselves. These are the tribes in this basin. The Milk River flows north out of Montana into Canada, but it's part of the Missouri River Basin. They've been there for a very long time. The Gros Ventres go all the way down into northwestern Wyoming. The Gros Ventre Mountains are named after that tribe, okay? It shows you these tribes move, and they've been moving for their entire histories. So in 1888, you have a classic example of the United States forcibly placing the tribes on reservations. A reservation is a legal term. There is land in the public domain, land that we purchased from another European power, France, through Louisiana Purchase. And under the doctrines of discovery and conquest, starting in the 1820s, the Supreme Court held that the United States obtained title superior to those of the tribes. The tribes were not capable of conveying title. This was settled law by the 1880s, but we have all of this land that the United States holds and is slowly parceling out through the homestead laws. But what Congress or the executive can do is withdraw that land from settlement, that's called withdrawal, and then reserve it for a particular purpose. So some of the first reservations were for military bases. We're going to withdraw this land from the Homestead Acts and build a military base. We're going to withdraw this land from the Homestead Acts and dedicate it to a tribal homeland for the Indians. We're going to withdraw this land from the public domain and reserve it for a forest reserve, a national forest. Okay? So reservation, that term is not limited to tribes. It's a term about the withdrawal of land held in the public domain, being withdrawn from the public domain and dedicated to a particular purpose. So back to the Winters case. In 1888, the United States forcibly places these tribes onto tiny fractions of their homelands and open the rest of the region up to settlement under the homestead laws. 1889, Montana enters the Union. 1895, these dates always matter because it's water law. First in time, first in right, okay? White irrigators settling under the homestead laws, under the Homestead Act, under the Desert Land Act of 1877. They are upstream on the Milk River. They start diverting water for their farms and ranches, and they dry up the irrigation project the United States was building for the tribes in its trustee capacity. So the United States sues in its trustee capacity on behalf of the tribes. So the issue really is, okay, the reservation is 1888. The tribes are not putting water to beneficial use. But the white settlers that obtain title through the Homestead Act do obtain title to the land and start putting water to beneficial use. They're following the law, perfectly law-abiding. They get 1895 water rights. So who has a superior right to the waters of the Milk River? And this is what the court has to wrestle with, and it does so in handing down this decision. Basically, it says, look, we're going to follow treaty law. We're going to interpret these reservation treaties and other agreements as contracts. Who wrote the contracts? The United States. We're going to interpret that contract against the best interests of the grantor. So we're going to interpret that on behalf of the tribes. The tribes never would have given away their water rights. So even though the treaty does not mention water rights, the purpose of the reservation, and again, I'm quoting from the decision, was to turn uncivilized savage Indians into resident agriculturalists. Because we know how civilized farmers are, right? We are going to improve this process And that is racist, that is out of date, but there's an interesting side to it. What do waters need? What do farmers need? Water, and a lot of it. So the court said, when the tribes agreed to these treaties, they reserved the water rights necessary to effect the purposes of the reservation. And if the purposes of the reservation are to build lasting farms, these tribes are going to get a lot of water. And I want to emphasize, this was not something that the United States conveyed to the tribes. This was something that was the property of the tribes at the time of the treaty. They conveyed land, they reserved their water. They never conveyed their water rights away. And these are early 20th century cases that are just following American property law and the logic of contract interpretation. So the tribes have property rights under federal law. What's the priority? The date of the first reservation. In this case, 1888. How much water do you need? As much, as I said, to effect the purposes of the reservation. And the United States can do this after a state enters the Union, because the United States still owns all of this land it's parceling out under the homestead laws, and it's a trustee for tribal reservations. So as a result, the tribes have an 1888 priority to the water rights within the Milk River, which is senior to the white irrigators' 1895 rights. Okay? This is the foundational decision that grants, I shouldn't say grants, that recognizes tribes' water rights under federal law. The next case is, before I go ahead, any questions on this?
Any questions so far?
Okay. You're being very polite. I'll keep going. Next slide, please. The biggest water case in American history, Arizona v. California, to waters of the Colorado River Basin. This is, at one level, a fight between two states that have hated each other forever about water, Arizona and California. But the federal government plays a large role in this. The United States intervenes because there are federal properties in the basin. There are national forests, there's Bureau of Land Management land, there are national parks, but there are also about 39 tribal reservations in the basin. The United States actually opposes the entry of some tribes. The Navajo wants to come in on their own. The United States fought that. But again, the issue now is a little different. We have winters. We know the tribes have water rights. We know that the priority of those water rights dates from the founding of the reservation, from the treaty. How much water? And the special master, who is the judge in this case, determines that the metric that should be used is called practicably irrigable acreage. Let's say you've got a 100,000 acre reservation, and 40,000 of those 100,000 acres can be put under irrigation. And you need 3 feet of water per acre. And under that simple lawyer math, that's 120,000 acre feet of water. It's a lot of water. And guess what your priority date is? The date of the treaty. So in the case of the Navajo, that's going to be 1868. When did Arizona become a state? 1912. Old, big water rights. The baseline, the default metric is practicably irrigable acreage. The states evince surprise at this because they can't believe the court meant what it said in 1908 when it said the tribes have big, old water rights. And if you look at this, Arizona wins this case. No one thought Arizona would win this. They snatch victory from the jaws of defeat. They get 2.8 million acre feet of Colorado River water. They get all of the Gila River. But the court makes very clear the tribe's water rights will come out of the state's allocation. And if you're looking at the Hopi, the Navajo, and the other tribes in Arizona, about 1 million of those acre feet are going to be dedicated to tribes. We'll come back to that. Next case is the Colville case, and I think this is the last case I will summarize. This is a really interesting case because it has to do with customary fishing rights. You have a lot of cases out of the Pacific Northwest. This is a case out of Nevada dealing with Omak Lake. Other lakes in Nevada, such as Pyramid Lake, have been subject of a lot of litigation. The treaty that the American ambassador reached with many of the Northwestern tribes, his name was Stevens, so you may see references to Stevens treaties. They recognize the aboriginal, and I'm mispronouncing that intentionally. It is more than original. It is before original. It is aboriginal right to use these streams for fishing, for salmon, for steelhead, most importantly, but also on the coasts. The issue here is, how do you recognize that as a water right? That's the first issue. The second issue is these reservations in the Northwest have a substantial amount of allotted lands. So you have tribal members who own lands as individuals, and you have non-tribal, Washingtonians, Nevadans, Idahoans, Oregonians, who have purchased or otherwise obtained these allotment lands. How do those work out? And Colville resolves that in two very simplified ways. Next slide, please. First thing is the court. Now, again, this is not a Supreme Court case. This is the Ninth Circuit case. It was appealed to the Supreme Court. The Supreme Court did not take it and has not taken a case like this ever since. Again, a very strong legal win for the tribes. The tribes are entitled to flow and water levels that are necessary for these fishing purposes, but also for ceremonial uses of water. And because these are cultural uses that the tribe has always employed, these date from time immemorial. You want to talk about first in time, first in right? You now have a priority date without a number to it. It's going to be the oldest water right in the basin. Now, what about the allotees? How do we quantify their right? Generally, it's proportionate to acreage. If you have 40 acres and the general water duty for the land is a foot, you need a foot of water to irrigate, then you have 40 acre feet of water for that parcel. If you have 80 acres, 80 acre feet, and so on. Priority date of the reservation. Because these are federal water rights, they are immune from abandonment. You can abandon a state law water right. You can have a water right in Kansas declared to be abandoned. It's basically forfeited, but we call it abandoned, maybe because the legislature didn't want to use the F word, right? A tribal member who owns as an allotee an individual federal water right is immune from abandonment. But when that tribal member sells or conveys that water right to a non-Indian, it becomes subject to abandonment. So, next slide, please. How much water did the tribes reserve? Well, I've covered some of this, but there is no hard and fast rule to quantifying a water right. Winters obviously uses squishy language, right? Enough that can satisfy the reservation. Arizona v. California uses practically irrigable acreage. A water rights adjudication on the Gila River uses 6 factors. I won't just read the slide. It's bad enough that I'm giving you this PowerPoint in the first place. But you can see the factors, right? How much water they've used, what are their cultural needs? Is it really dry? They might need more water. How does the tribe make money? What is the economy of the tribe? Are they really dependent upon agriculture, or have they done other things? Do they do everything? Like with the Navajo, they're farming, they're mining, they're running energy plants, doing all sorts of things. Here in Kansas, the tribe used a pretty creative thing called a municipal build-out. They basically let's treat us like a city. There's not a lot of farming on the reservation. We want to be able to use this water to increase economic development. Our population is slowly growing, and the parties agreed to that. So the next slide, I'll try and reduce these basic rules into one slide. Please do not depend on this. Call me before you're going anywhere else. I can give you much more detail. Tribes are entitled to very strong, implied, reserved federal rights with the priority of the earliest treaty or reservation. Cultural uses of water are going to be recognized. We have various ways of quantifying. There's a recognition that the PIA standard is a pretty crude metric, so you'll see other ways of quantifying it, and allottees have the rights that I described and don't need to repeat now. Okay, next slide. This is the problem. I'm going to be using the rest of my time to describe this very complicated problem. Tribal water rights are powerful on paper. They've been consistently recognized under federal law. But just because the Supreme Court says you are entitled to large amounts of water with the senior priority water date does not mean that you are getting wet water, and that actually is a phrase in water law, wet water, actual water to your reservation. Supreme Court case from last year where the Navajo Nation sued Arizona, they were arguing that the treaty the Navajo made with the United States in 1868 included a duty to physically get water to the reservation. The Supreme Court said, no, we don't see that in the treaty. So the challenge here is you have on paper large and strong water rights, but without the political will to translate those legal rights into actual water projects and water treatment plants and reservoirs and irrigated farms, these rights are not worth a whole lot. And I think a good comparison is the 14th Amendment, right? We had a civil war, the good guys won. We passed the 14th Amendment, the Equal Protection Clause. So on paper, freed blacks had all sorts of civil rights. Did they enjoy those civil rights? Not for 100 years in many parts of the country, right? It took 100 years for Congress to act to recognize the 14th Amendment, articulate it in things like the Voting Rights Act and the Civil Rights Act. I think there's a very strong parallel with Indian water rights. On paper, we've had them since 1908. But across much of the West, tribes are so water short that they still have to truck water for domestic use, often 30 to 40 miles. It's especially dire in New Mexico and Arizona because it's so dry. You've got to deal with racism. You've got to deal with political pressure. You have to deal with a lot of obstacles here. So, how are some of the ways that Western states and tribes and the federal government have tried to mesh this federal system of tribal water rights with a state system of state-based water rights? This gets us to adjudications. An adjudication is basically a huge, quiet title action. We've granted way more water rights than the water can supply. So what we're going to do, usually the state legislature passes a statute authorizing the adjudication, sometimes setting up its own water court, as has been done in Montana and is being done in other states. And everyone who's got a water right claim can come in and convince the court that that claim is valid. Fortunately, we don't face that problem in Kansas because of the 1945 Water Appropriation Act. We know all the water rights, but there are some states where you have a constitutional right to a water right, like Idaho. They dealt with over 900,000 water right claims in the Snake River Basin adjudication. And about 200 of those were laughably just ridiculous. Have you ever put the water to beneficial use? No. But the Constitution says I have a water right. Well, no, you don't. The Constitution grants you the right to obtain a water right. Okay, so think of it as a massive bankruptcy proceeding where you're trying to balance the system. There are 100,000 water rights claims. there are 50,000 water rights units. So the state's going to be a party. The United States is going to be a party on behalf of federal lands it owns and its trustee capacity for tribes. And the goal is trying to balance the system. And some of these adjudications I mentioned here, the Snake River or the Gila General Stream Adjudication, I'll talk about briefly. Okay, next. Tribes play a very large role in these because of their winter's rights. So the Nez Perce tribe had over 5,000 water rights claims in the northern part of the Snake River in Idaho. That issue had to go to Congress. That required congressional legislation basically to negotiate the Nez Perce claims. The Hopi and the Navajo have been trying more than my entire life, since the 1950s, to try and make their very strong legal rights actually convert to water. But the tribes have these strong paper rights. So immediately upon the beginning of an adjudication, the tribes have the legal power. And that gives them certain negotiating power too, okay? And this is why when you have an adjudication, say of the Gila River or of the Upper Rio Grande in northern New Mexico, it almost automatically promotes hard negotiation. Next slide, please. And this has to do with sovereignty. The tribes have very strong legal claims, but they're often politically weak, they're often poor. Non-Indian state water rights holders, irrigation districts, large farming interests, have junior rights under state law, but they're very strong at the state legislature. They also have access to credit. They can borrow money. The United States is caught between these two parties, right? They're a trustee for the tribes. They provide massive subsidies to farming, including massive federal irrigation districts. Okay, about 80% of the irrigation water on the surface in the West is provided to farmers through the Bureau of Reclamation, which we all paid for, whether we farm or not, okay? The United States can also do the best thing you can do in a water rights settlement is bring money to the table. So, next slide, a very common settlement profile would be something like this. The tribes have massive water rights claims, but they're willing to negotiate a lower number. Let's say we're entitled, like the Crow tribe is entitled to in southern Montana, to 800,000 acre-feet of water. That's a lot of water, okay? We'll take less than that if we can be allowed to do certain things. Can we lease part of those water rights off tract? Think about how much money the Navajo could potentially make if they could lease water to Phoenix. Okay, so exchanging a reduced amount for flexibility in marketing. The state parties are going to have to accept reductions because that's how the prior appropriation doctrine works. But oftentimes, they're willing to do that if a court, through an adjudication, says, okay, through this process, we can certify you have a certain water right. Again, that's not as much of a problem in Kansas because our water rights are better defined. Almost always, these settlements go to Congress for congressional approval, and funding is the stumbling block. So I'm sure this committee is very well versed in all the difficulties of actually seeing a water rights settlement made. That's the first step. The second step is getting the money, usually from Congress, to fund the terms of the settlement. So I'll use the last part of my time for some examples. And I'm using these because there are three different forms. The first is you can do a compact. That's what Montana has done. Kansas, we have resolved it largely between the state and the tribe, and then we are asking Congress to fund and authorize it. And Arizona has done it through a general stream adjudication, or GSA. Okay, next slide. For Montana, they've done 7 compacts with the tribes. Now, under the Compact Clause of the Constitution, states can make treaties with one another. They can make contracts with one another. And when Congress approves that contract, it becomes a compact. We have the Arkansas River Compact with Colorado, the Lower Arkansas River Compact with Oklahoma, the Big Blue River Compact with Nebraska, and the Republican River Compact with Nebraska and Colorado. Congress approved those. It's state law, it's federal law. Because tribes are sovereign, you can have a compact with a tribe. So these are 7 of the tribal state compacts that Montana has done. Again, getting the paperwork done took a long time. I think Montana should be praised for these. But again, a lot of this has not been fully affected because of funding. The next slide is why the slide is a 13 megabyte slide. Thank you, state of Montana. The shades of blue, light blue, those are the tribal compacts. And you can see in the southern part of the state, the Crow. But the Crow settlement, even though it's a compact, is still awaiting congressional authorization for funding. Next slide, please. Okay, the Kickapoo settlement, much smaller reservation. Remember your Winters rule, date of the first treaty, that's your priority. Check that out, October 24th, 1832, before we even have Kansas territory. Why? Because that's the first treaty the Kickapoo signed with the United States, the Treaty of Castor Hill in Missouri, when the reservation was basically northwestern Missouri and northeastern Kansas. So that's their priority date. That is, as we know right now, the oldest water right in Kansas. It uses the municipal build-out standard to quantify the right. It allows the tribe to market water off reservation. It allows the tribe to build a reservoir to store around 3 years' worth of water. It requires the tribe to establish a water code. And it as an appendix, has a memorandum of agreement, an MOA, so that the state and the tribe can keep each other apprised of what's going on. The state will report to the tribe how many water rights have been granted in the basin, how's the water right portfolio changed, and the tribe will report its progress. Happy to take questions on that more, but I would say that the Division of Water Resources and the Attorney General's office are going to have more current information than I do. Okay, next slide. This is in what legal experts call a cluster. All right? In your haste to put tribes onto some of the least arable land in the United States, you unwittingly made them the most powerful water players in the state because of Winters. If you look at the size of the Navajo Reservation in Arizona, under the PIA standard, they get close to 1 million acre-feet of water on paper. These are all the tribal reservations. We have 4. Arizona has many more. Next slide, please. I want to flag a couple things in the lower Colorado River, the Little Colorado River general stream adjudication. This is a tributary of the Colorado in Arizona. And I've put this number in highlights for a reason. The parties quantified the right for the Hopi tribe according to the 3 main uses of water: irrigation, which they used for a PIA standard, economic development, and what's called DCMI, domestic, cultural, municipal, and industrial, sort of everything else. What they do is they try and estimate how many gallons per capita per day does someone need under this DCMI standard. We will multiply that by the number of people to get that gross number. The entirely white communities of Winslow and Cottonwood, Arizona, had their rights quantified at 150 gallons per capita per day. But look what the court held the Hopi were entitled to. 90. My colleague who teaches water law at Arizona State, Rhett Larson, just flat out calls that what it is. You're discriminating, you're reducing the gallons per capita per day for tribal members as opposed to others. So, in conclusion, next slide, please. Negotiated settlements are unquestionably superior. You're not going to beat the tribes. 2 reasons. The United States is going to represent the tribes. Second reason, the law is consistently extremely strong on behalf of the tribes. So negotiate it. That's the good news, because if you start negotiating, you can start making your own reality through the magic of contract law. How much water do the parties agree the tribe is entitled to? How should we quantify it? Kansas has the best water use data in the world, which was a huge help. Kansas has the prior appropriation doctrine for groundwater and for surface water. So it caused the chief engineer of the Division of Water Resources no heartburn at all. Tell me what the priority is, tell me what the amount is, I'll protect it. It's what I do. It's my job to protect water rights according to the prior appropriation doctrine. And because our tribal homelands are not that big, and because we are not in western Kansas or, heaven forbid, Arizona, these are doable. And I would urge you guys respectfully but firmly to try and use your power and influence to get this done. Compared to many of the settlements out in the West, these can be done, and in your lifetime. Okay, thank you.
Wow. Boy, that's a proverbial can of worms, isn't it? Yeah.
Yeah.
Committee questions? Representative Hastwood.
Thank you, Mr. Chair, and thank you, Dr. Griggs, for that presentation. You mentioned with about the compacts in Montana, the tribal compacts. So those were wanted by the tribal nations, right?
Yes.
Okay, and then you mentioned that one of the biggest obstacles is funding and approval by Congress.
Correct.
Funding for what?
Usually for the water infrastructure that will make the deal.
That gets paid.
The state irrigators will agree to less water. The tribe will agree to less water than their winter's rights, provided the United States, acting through Congress, authorizes enough money to build a reservoir or build irrigation systems or do other things. So we have an agreement, it's signed, like the Kickapoo tribe, Governor Brownback, Attorney General Schmidt, the head of the tribal chairman of Kickapoo signed it, so did David Barfield. But that agreement explicitly references the need for congressional authorization to complete and effectuate the agreement.
Okay, so it needs to, the money from Congress would pay for the infrastructure of the entire projects.
Or large parts of it. Maybe the state contributes a large part of it, as you see in Arizona or Utah. The states have contributed money as well.
Okay, thank you.
Yeah.
Any further questions? Representative Akala.
My eyes open now. What would be your prediction or your opinion on permanent depletion?
This is, I think you mean like the permanent depletion of water supplies. I think it's something to be very concerned about. We've seen it in the western part of the state. Groundwater is really good stuff. Think about how awesome groundwater is. It's always there. You don't have to rely upon a high flow year or a good flow year. If you have a junior water right, you can still pump out of the ground. The water is generally cleaner. So even in humid parts of the country, groundwater is becoming very popular. It blew my mind the last time I went to Mississippi. I'm driving between Memphis and central Mississippi. All the farms have center pivots on them. I'm thinking, this is insane. This is the Mississippi Delta. The farmers can time their irrigation. They can do what they need to apply the water when they need it, where they need it. So there was so much groundwater pumping in Mississippi and so much groundwater pumping for the city of Memphis that those two states, Mississippi and Tennessee, ended up fighting in the Supreme Court over the groundwater that straddled their states. My long-winded response is, even in a relatively wet part of the country, North Florida, South Georgia, eastern Mississippi, groundwater levels are going down. And unless we reduce our water use, they're going to continue to go down. The northeastern part of this state, there's not as much groundwater. It's not like the High Plains Ogallala Aquifer. It's glacial pocket groundwater. Chief Engineer Lewis could probably spend an hour telling you about the hydrogeological characteristics of that water. I'm not the guy. But if you grant too many water rights to a particular basin, because groundwater and surface water are connected, those streams are going to go down. And it's going to take a long time for that pumping to become visible in the stream. But once that pumping does affect the stream flows, it's going to take the same amount of time to restore that stream level. So even in a relatively humid, relatively water-rich place like northeastern Kansas, the risk of permanent depletion is real.
Committee, further questions? Justin?
Professor, thank you. When is the water right tied to time immemorial versus the establishment by reservation by treaty?
It has to do with whether you're dealing with, say in the Colville case, a use the tribe had made of water for its entire history, say for salmon fishing or for harvesting wild rice in Minnesota. That was something they were doing with the water before the tribes were put on a reservation. Okay, those are going to be time immemorial, or what we call Walton rights, because one of the figures in the Colville case was named Walton. That's a water right with a priority date of time immemorial. If you were dealing with a situation where the United States forcibly put the tribe on a reservation to turn them into something else, we're going to take these nomadic tribes and turn them into resident agriculturalists, or we're going to do that with irrigated agriculture, then that's going to be a winter's right with typically the practicably irrigable acreage standard with the priority date of the reservation.
Are all those reservation rights, senior rights in Kansas? Are those the most senior water rights?
We do not have, as far as I know, and this may have changed since I left the employ of the state, a established priority date for the other three tribes, but it would not be hard to ballpark it with reasonable precision if you find their relevant treaty histories. And oftentimes these tribes have multiple treaties, because every time there's a second treaty, it usually means they're signing off more land and more interests, like with the Kickapoo. There are, I think, 3 or 4 treaties the Kickapoo made with the United States. The Supreme Court makes it clear it's the first one that matters.
Committee, further questions? I just have one, so, and maybe this would be better addressed to the Attorney General or something. So what is the status of that water rights with the Kickapoo at this point in time? Is it in Congress?
Yes.
And so the holdup is Congress?
Yes. And we are trying, by we, I mean, I think the tribe, the lawyers for the tribe, they've been very well represented by the Native American Rights Foundation, which is a firm that represents tribes. They have tried to exploit what's called the Multi-Purpose Small Lakes Program as an act of Congress that passed in the 1950s. Maybe this is a way to get funding that would not otherwise be available. One of the reasons a lot of these tribal water rights settlements got stalled in Congress is because in the 1990s, the leadership of the Committee on Indian Affairs and Interior, they passed certain rules prohibiting, I'm sorry, maybe I'm just got stage fright because I'm in front of a lot of elected representatives. What's the term for a pork project that benefits your district? Pardon me? Sorry? Well, not pork barrel, but like certain legislation, like Senator Byrd from West Virginia was great at this, right? This is why the highways in West Virginia are so awesome. You can't bring to my committee a piece of legislation that will only send money to one district or to one state, right? So there was a representative from Nevada, Ron Bishop, and he issued this thing called the Bishop Memorandum. And he said, look, if you want me to hear any water rights settlement, it has to comply with the Bishop Memorandum, which his lawyers wrote, which said, I need multiple reservation settlements. So a classic piece of legislation will be, we're going to do the Crow in Montana, we'll do the Rocky Boys in Montana, we'll do Southern Ute in Colorado, we'll call it good, okay? And since part of Southern Ute is in New Mexico, we got 4 states, it's not, it passes that test. Bishop's no longer in that position, so that's no longer an obstacle. But honestly, more than half of the fight is getting funding from these through Congress.
Thank you for that. Committee, further questions? Very good, Professor. Thank you so much for that.
Any follow-up, just shoot me an email. You know where to find me.
Very good. Thank you again. Okay, next we have updates from the tribes. And first we have Prairie Band, Potawatomi Nation. Joseph, thank you for being here.
Whoop, there we go. Distinguished members of this committee. As the chairman stated, my name is Joseph Rupnick, and I serve as the chairman for Prairie Band Potawatomi Nation. I'm a veteran of the United States Cavalry, lifetime member of DAV, lifetime member of VFW, and active member of American Legion. I represent approximately 4,500 Potawatomi people, most who live on the reservation in Kansas, defined by our 1846 treaty. Part of that, and we had heard today that most of Potawatomi, we were a Great Lakes tribe. 1834, President Jackson signed the Indian Removal Act, and we were forced to move from our homelands and cede lands in Illinois. From there, we moved through Platte County, Missouri. At that time, Missouri was trying to become a state in the Union. One of the rules was you had to have more European settlers in the state than Native Americans. So Missouri didn't want us there. We ended up moving to Council Bluffs, Iowa. From there, we signed the Council Bluffs Treaty, where our folks came down here into this area and looked for a place for us to settle. And we eventually signed that treaty 1846 for this Kansas reservation. On that reservation, we purchased 900 square miles within this territory. Those funds come from the lands that we ceded in Illinois, plus the lands that we ceded in Council Bluffs, Iowa, to hopefully have a permanent home in Kansas. About where, just south of Holton, probably about 4 miles, maybe not quite that far, yeah, about 4 miles. There's the beginning of the Prairie Band Potawatomi Reservation. There's a marker post there. That's approximately the original northeast boundary of the original reservation. Then that reservation would extend from that corner 30 miles south, 30 miles west, for a total of 900 square miles. That's what we bought. We heard this morning some of the folks talking about the Allotment Act, the Dawes Act. That was one of the ways that the government reduced a lot of our reservation. Under that 1846 treaty, that 11 by 11 was supposed to be considered common ground or common lands by treaty, meaning that nobody was supposed to own that. Nobody was supposed to live on there. That was an area reserved for the Potawatomi that they could do with as they wish. Most of our members lived west and south along the Kansas River and along those areas there. Once Dawes came around, then they started rounding us up again and forced us to take allotments on the 11 by 11. Because of that process, our reservation is very checkerboarded now. Because of the Dawes Act, individuals could hold that land for 25 years. There was no work. There was nothing out there to help feed their families. Many of those members sold their interest. My grandfather, for example, he thought he was signing a farming lease. When he went to go collect the money from the crops, then the guy came up and told him, said, well, Johnny, you sold me your land. You're not getting anything. And so because our folks couldn't read English very well, or they didn't understand what they were signing, there was outright theft. And that happened up until the 50s and 60s. So we have a lot of folks that are non-tribal that live within our lands, meaning that it's checkerboarded. And because of those mixed parcels, some of that tribal jurisdiction, who has rights, who can prosecute under that, those police have to know approximately 5 different types of land. So number one is who committed the crime. Is it tribal or non-tribal? And what type of land is it? And that's going to determine where those cases go. I know that, it was brought up this morning that the Indians are the only ones that can be prosecuted in 3 different courts. And that does happen. So we do have folks that get charged in tribal court under tribal crimes. The county, Jackson County, sometimes says, well, we don't think you guys gave them a harsh enough penalty, so we're going to prosecute that. Then they get charged in state court for the exact same crime. That happens today, and it's still going on. And that's part of that overreach because of the Kansas Act. The first part that I want to kind of talk about, too, is maybe starting from the beginning. And whether you guys want to admit it or not, it was actually the Indian tribes that legitimized this government, the United States government. Because when they first signed the first treaties with Indian tribes, that's where we recognize them as a legitimate government. And from there, they used that to break away from the British government. That would hold true for their currency as well, because they paid Indians with currency that they were forging or making at that time in lieu of payments because of those treaties, and we legitimized that currency that the United States government had. So our histories are intertwined. And because of that, we choose to ignore that. And part of that is to kind of turn a blind eye to history, knowing how we come together on a lot of those different issues. When the framers drafted the Constitution, they understood the importance. And one of the things is Article 6 of the U.S. Constitution, and in there it states that the U.S. Constitution and the laws of the United States, which shall be made in pursuant thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. One thing to note is that the Potawatomi people, we have the most treaties signed of any tribe in the United States. We have 44 treaties signed with the U.S. government. Every one of them have been broken in one form or fashion or another. To include this last one here in the state of Kansas, our 1846 treaty. We talked about, that government-to-government relationship between tribes, and that's also in Section 8, the Commerce Clause. And in that, it says, Congress shall have the power to regulate commerce with foreign nations and among the several states and with Indian tribes. So in our U.S. Constitution, that's where that gives us that autonomy for Indian tribes that we have here today. I think it's kind of, everybody likes to say that they follow the U.S. Constitution or they tout that, but they only pick and choose certain portions of it when it fits their narrative at that time. And so what we need to do is really look at that and make sure that those tribes, those ones there that have that federal recognition, hold the U.S. government to those trust responsibilities and those treaty obligations. This morning we were talking about a little bit about state tribes. And one thing, because many of the tribes here signed treaties with the U.S. government, we are considered a political class. Yes, we are a race, and we are defined by our membership as a race and so on and so forth. But for the purposes and law of the U.S. government, we are a political class. 25 CFR, we heard that this morning. That's a book. It's titled Indians. That's all Indian federal law. It's about that thick. And because that Indian law is so complex and ever evolving, you need somebody that specializes in that law. And that thing is, I'm not a lawyer. And to be able to go through that, that's why we have to hire lawyers and multiple lawyer firms just to be able to make sure that we're complying with the CFR 25 CFR, and we're making sure that the federal government holds its, or we're holding them to those obligations. From that 1846 treaty, we started occupying this area here around 1847. So that was at 900 square miles, which would come down here past, a little bit past Topeka, and then west 30 miles. That was our original lands. Now, one thing that I want to note too, and one of the first laws that the U.S. Congress passed was called the Indian Non-Intercourse Act. And under that act reserved the right for U.S. Congress to enter into treaties specifically for Indian tribes. Before that act was started, some of the states were entering into treaties with tribes. They were taking lands. They were trying to negotiate deals, so on and so forth. Once the Continental Congress got together and they enacted that law, then that right was reserved for Congress. That's important because when those treaties, and under Article 6 of the Constitution, when Congress enters into those treaties with those individual tribes, only Congress can disestablish or change that treaty in negotiation with the tribes. Not an agency, not a state, not any other individuals. Congress has to make that change. Now we come into Kansas. In 1854, Kansas-Nebraska Act was introduced. We have been occupying here almost a decade, and in that act, right, it says that provided further that nothing in this act shall contain or be construed to impair on a person's rights, properties pertaining to Indians in said territories so long as such a right remains unextinguished by treaty between the United States and Indians, or included in any territory by which any Indian tribe is not without consent to that tribe to be included in that treaty. I can't speak for the other tribes, but I know Prairie Band Potawatomi, we never agreed to be a resident or submit to the state of Kansas. We have always maintained our tribal sovereignty, and we have always maintained that we are a sovereign nation. So then we kind of move forward to the actual adoption, or the Kansas Act, and adopts its initial decision. And what they had done, I think from the, if I remember correctly, that was a Wyandotte Constitution that they finally went ahead on and got everybody to vote on and agree to. There was only one section in there that dealt with tribes. And that was under the ordinance section, section 1, Kansas will not interfere with the United States to such lands or with any other regulations of Congress in thereunto of. sections number 16 through 36, in each township in the state, including Indian reservations and trust grounds, shall be granted the state for the exclusive use of common schools. That's it. The reason why I think that Kansas did not have anything pertaining to Indian tribes is because of the Kansas-Nebraska Act. And then the act that actually admitted Kansas into the Union, of course, that was dated January 29th, 1861. They took the exact same language from the Kansas-Nebraska Act and inserted that into that act in Congress to admit Kansas into the Union, which, when I go back, it says that Kansas doesn't have anything to do with the tribes unless they agree to submit to that jurisdiction. Again, Indian law is complicated. There's a lot of different things that go along with that. Now, today, we're kind of living in a post-McGirt world. And under that McGirt ruling, Justice Gorsuch wrote, today, we are asked whether the land these treaties promise remains an Indian reservation for the purposes of criminal law. Because Congress has not said otherwise, we hold the government to its word. Again, that reaffirms that Indian Non-Intercourse Act, that reaffirms the intention of the United States Constitution, and it reaffirms those treaties that the tribes entered into with the United States government to say, these are our lands. We have sovereign jurisdiction over them, and those rights and those responsibilities belong to them. One of the things that I know is that this tribal state relations, there are a lot of MOUs, resolutions, and things like that that kind of pass out through here, and I have to go back and look at them. Everything that was through here since the 1990s, I forget the date that they had on here, but I think it's important that we start those conversations and at least learn about the history, what those laws are, and how we can work cooperatively together as we move forward on that. I think that it's important that this body here and the both houses of the legislature understand the treaty obligations and responsibilities that we have. As you know, and what we've heard today here, the tribe's authority is affirmed by Supreme Court cases, and currently right now we have a federal lawsuit against a county sheriff for overstepping his authority. We entered into a business agreement with a non-tribal person. They refused to abide by our laws, even though they agreed to that. And then the sheriff tried to stop us from enforcing our laws. We filed a suit against him, and we're waiting to see where we're at with those individuals there. So, you know, we tried to enter into an agreement with this individual, the sheriff. When we first started there, he pretty much thumbed his nose at us and said, you know, you guys can't protect yourself. I'm here to protect you. Even though our tribal police go to school out here, they are state certified. The Kansas legislature passed a law that allows our tribal officers to arrest and charge non-tribal with state crimes. And our tribal officers are federally licensed through the Department of Interior. So I think that we do have that authority. You know, I really don't appreciate the county. They have tried to file federal law or federal legislation looking for somebody to help them out because they were saying that the nation is a burden on the county because the nation has land that is put into trust and the county can't tax. One of the problems is, as I said, that, you know, you're quoting 33,000 acres that the nation has in trust. 16,000 plus acres was individual allotment land from the Dawes Land Act in the 1890s that you never had any control of over to begin with. So you can't use those numbers. And over the past 25 years since we've been operating a gaming, having gaming operations, yes, we have purchased land. We have placed those back into trust. And this is the second time that we're purchasing land on our original reservation or within the common lands of our reservation. There are many areas that we are fighting on different fronts here, but you know, we want to be as good a neighbor as we possibly can. I know one of the questions was does Jancita need some help over here? And you know, she does an excellent job, and I couldn't agree more. One of the proposals that I submitted to the governor was Wisconsin. Wisconsin has a good tribal relations model, and they have, you know, broken it out where there is actually a training piece for new lawmakers coming in that identifies tribal leaders. What does it mean to have tribal relations? What does that tribal state relation look like? And who can we contact to? I think that that is a good model that maybe Kansas ought to look at. So again, I don't think, I think somebody had mentioned, well, we'd have to take that through budget and see how much that costs and all this other kind of stuff. But, you know, that's why you guys are the lawmakers and you get paid the big bucks. One of the other ones there, you know, we talked about, and I kind of have a problem with those folks there, which are the state recognized tribes. And I know that there are a couple of groups out here that are seeking that. And I know that this is a concern across Indian country. And it's not just here in Kansas, but many states around the United States. Keep in mind, though, that in April 19th, 2024, there were 15 states that did not have Indian reservations. April 19th at 11:30, 2024, I conveyed land to the U.S. government, and that number of states that do not have Indian reservations was reduced to 14 when the U.S. government reaffirmed our reservation in the state of Illinois. So that is a huge win. But you're right, a lot of states don't have tribal relations. I mean, you've got 14 states out there that never have tribes. They don't recognize tribal reservations or anything like that. But one of the things that we have seen when I go back to these state tribes is many of those individuals don't have treaties. They can't go through the federal process because they don't have a history. A lot of times they steal culture and tradition from those other resident tribes, claiming that it's their own, with the only hopes of either establishing a casino or taking advantage of federal funds. Now, I have been told by our lawyers that really we need to look as Indian tribes and look at those different agencies or those different states, because we feel that those states that are recognizing those groups of individuals, they are recognizing them as a race group and not a political group, because they don't have that status with the federal government. And if they are identifying and giving them special privileges because of their race, then we feel that they are violating the Equal Protection Clause, the 14th Amendment that we just heard of the U.S. Constitution. That's what I think the legal ramifications are when you recognize state-recognized tribes. I know that some of the nations across the United States are looking at and trying to get everything together to look at possible lawsuits for those individual states, because some of those benefits directly impact us and we can show harm. So 8A contracts, which are federal contracts that are specific to tribes that our LLC competes for, state-recognized tribes in those other states are eligible to compete with those too, and I don't think that's right. Lastly, one thing that I would like to add is one of the mentions here early this morning, and they were talking about hunting licenses. And on the state, and I would ask this body recommend that all blood quantum references be removed from all state language or statutes. I think they said that you had to be 1/16th blood quantum, or you know, you had to show that you're 1/16th ended. You know, if you have a descendancy card from Interior, you can go up there and get that. Otherwise, you're going to be a tribal member. And that was part of the federal government's way of essentially eliminating us by placing a blood quantum on tribes to figure out who was in it. All that goes back to that genocide era where they were trying to eliminate tribes. And what they were doing, and that was one of the federal bills that I've got up in Congress right now, is to get that removed from the Jay Treaty, because Potawatomis, we have 7 bands in the lower 48, and we have another 6 bands that we recognize in Canada. So when that removal period came about, everybody kind of scattered. Those are still our brothers and sisters that live up there. We didn't recognize the border. That was just something that was imposed on us through the U.S. government. That's all I have. I've emailed my testimony, and thank you for the time, Chairman, and I will take any questions.
Good, thank you. So just to staff, you guys are getting these notes and stuff so we can go back through them, because I can't write that fast. So committee questions? Very good. Thank you very much.
Thank you.
Your testimony has been very informative. Okay, next we have the Iowa tribe. Timothy, Rod. Timothy, welcome to committee.
It's just some information about the tribe and some of the initiatives and stuff, projects that we've got going back up home. So, committee chairman and committee members, I'm also honored and humbled to be here with each and every one of you today to express those concerns that we're having on our homelands on the Iowa Tribe of Kansas Nebraska Reservation, located in northeast Kansas, southeast Nebraska. Also with me are representatives of the tribe. Both have served in previous leadership on the executive committee. Off to my left is Lance Foster. He is currently our Tribal Historic Preservation Officer, and he'll be speaking on some of the history and aspects of where we were, how we've got to where we're at, along similar to what Chairman Rupnick had presented on his tribe. And then we also have Alan Kelly. He's also previous leadership, and then also currently a part of the Tribal Historic Preservation Officer. So I would like to give them the floor and give a brief history of who we are as the Iowa.
Hodaka. As our chair said, my name is Lance Foster. Hirogre, Bear Clan of the Bakoji people. we are part of that whole process of removal when we got our official lands here, but we go back much further, at least till about 1100, 1200 AD. There's a National Historic Landmark on the border of Kansas and Nebraska on our reservation called the Leary Site. And our ancestral culture is called by archaeologists Oneota, and it comes from a term up in the upper Iowa River Valley in Iowa, which was named after our people, like South Dakota and North Dakota for the Dakota people. Iowa was named for our people. That was the center of our homelands, but like I said, we had a village here. We traded with the Pawnee and others that were resident tribes here, 1200, 1400, and that place was pretty picked over by collectors, you know, people who like to collect artifacts, and a lot of bodies were dug up, and we still struggle with that whole situation. So if you go from at least 1200, 1400, and we went out as far as Wakanda Springs as part of the trading, and even as far as the plains for buffalo. But in the year 1836, we signed the treaty that moved us across the river from the St. Joe Hills onto the lands that had just been recently ceded by the Kaw in northeast Kansas. And just north of that, Nemaha River was also another reservation in Nebraska that no longer exists. It was for the descendants of mostly white traders and Indian women during the early 1700s into the 1800s. We also signed several treaties which shrunk our reservation several times. We moved over here 1837, ceding all our lands in Missouri and Iowa over a series of treaties. And so we've lived there since 1837. This august body had transferred our mission to us in 2020. They're down by Highland, Kansas, the Presbyterian mission. And we made a commitment to the state. We'd always preserve it as a museum, as a mission, that's where it would always stay. And we have agreements and easements on it, and it's still been honored. So in 1854, as part of the Kansas-Nebraska Act, we have this weird name, right? Iowa Tribes of Kansas and Nebraska. Well, now you know why we're called Iowa Tribe is because there was the Iowa River, named for the river of the Iowas in Iowa. Then this territory of Iowa was named after us in the state of Iowa. But the reason we have that weird name is because we were here in 1836, 37, and then as part of the Kansas-Nebraska Act, drew that line right across our reservation, and so created Kansas, Nebraska, so we have the weird name, Iowa Tribe of Kansas and Nebraska. So the era from 1854 to 1861, of course, was the era of bleeding Kansas, and there were struggles. Iowa Point, which is up by our reservation, was the only place in the state of Iowa that was very Southern sympathies, since it was right across the river from Missouri, and it had a slave auction. The only one in Kansas was there. Now, by that time, 1854, all that land had been thrown open to non-Indian settlement. So between 1855 to 1857, such towns as Hiawatha, Horton, all these other places like this, Wathena, had been established by non-Indians. Initially, we didn't even get on the boat before the squatters came and started marking all the places they wanted. But it took about 2-3 years before the United States opened it up for sale. In the meantime, we moved up by the Nemaha River where we are today, and that land that was ours, at least about 9 acres of it is again ours. Through that collaboration, that partnership, we worked with the state and the support of so many legislators to do that. Because we are one of only 4 remaining tribes, so many tribes that got moved here, you know, there was that press, that manifest destiny that, you know, you wanted that land, you're going to get that land. So, but 4 of us found ways to stay, and that's who the 4 resident tribes of Nebraska or Kansas are now. And so we are basically in islands. So many of us have lost so much of our culture, our language, and And we struggle for that. We struggle to try to remain who we are in this sea, in this checkerboarding, as the previous chair described. All our spirits are in the land still. You know what? Ask where's Indian burial land? Well, it's all Indian burial land. We're in the ground all over the place. We've been here for 10,000 years plus, so we're everywhere. You're going to encounter us all the time. And there are so many issues that others more knowledgeable than I are going to discuss. But like all other tribes, we are challenged by some of the new things, ICWA and the Kansas Act and all these things that almost, in 1947, we were almost terminated, along with all the other tribes in Kansas. So I'm going to, before I say something really dumb, I'm going to go ahead and let the next speaker say something before I hog it all up, okay?
Alan, you got anything? That was one of the things I was going to bring up was the, of course, I wasn't prepared for this speech. This was a surprise. So, but anyway, the act, when Kansas tried to terminate the tribes, that always bothered me, you know, and took some of our sovereignty away. So we need to get that sovereignty back. We are capable of taking care of our reservation without, you know, the state of Kansas, you know, being involved in the law enforcement and stuff on our reservation. So that's something I think really needs to be looked into, and that we can reestablish ourselves as being a sovereign nation again. That was one of the things that's been bothering me for a long time. I served 3 terms as vice chairman. I was on the Kansas Water Committee, on the Missouri RAC, and I invited all the state legislators down to our reservation. Most of them never even knew we were there. And I fed them and everything, and we took them out to show where this area was that Brownback wanted to put this big lake and pump all this water to western Kansas, which was not a good idea. It was a crazy idea, actually, and it actually didn't happen. So I got my wish there too. Thank you. Thanks, Alan. So that'll lead me into our reservation. Like Lance and Alan had mentioned, we're in 2 different states, 3 different counties, and we have some of the same similar issues with jurisdiction and sovereignty issues that Prairie Band's experiencing down here in the south of the state. And one of those is our Fish and Wildlife Department. So our tribe has its own Fish and Wildlife Department. We have our own tribal codes. But what is happening due to the checkerboarded effect on our reservation is the state permits are being allowed to come in within the borders of the reservation to harvest our wildlife and our animals. And, you know, by those animals going through 3 different seasons through, you know, our own, the Kansas and Nebraska, that's putting a lot of pressure on those animals. And then in turn, you know, we have our own food plots. We're putting in a lot of our resources to add in, you know, those necessities that they need to survive, such as those food plots and mineral sites and, you know, other areas within the reservation boundaries as well. And what's happening is the state-issued permits are being allowed to be harvested, those animals within our reservation. The state gets all of the revenue off of those permits, and in turn, we are there fully funding our Fish and Wildlife Department as a tribe. And there's clearly a lot of issues where the jurisdiction is at play here because, you know, we are now positioning ourselves to have available acres designated for a safe place for those animals. Because those animals, those plants, those trees, those are all of our relatives, and we have to take care of all of our relatives. So I'm here asking the state to look into this. I brought this up several different times over my years in leadership, and still today there's nothing being addressed. So I'm asking, please find a way to support the tribes with their Fish and Wildlife Department and the laws and rules within the reservation boundaries. That also crosses over to law enforcement. I took leadership office in 2007. Prior to that, I served as a law enforcement officer, a canine officer for the tribe for about 8 years. And in being in 2 different states, 3 different counties, it's a lot of laws to retain. And we, like the Prairie Band, are sending all of our officers to KLETC, or the Nebraska Law Enforcement Training Center up in Grand Island, Nebraska. We're also sending our folks down to the federal certification with the BIA as well. So we still have currently today issues with local law enforcement, and we've been in support of contesting that Kansas Act and seeing if the state would find a way to support the tribes to let's take a look at that act and see if we can repeal that in some way or another and give the jurisdiction back to the tribes of our lands. We also have water issues, as a lot of states in the Midwest do. We are saturated in nitrates. It's been steadily increasing over the number of years, and you know, I've got to send water out to pregnant women and infants due to the increase in the nitrates. And I think we all know what's causing those nitrates, so I'm asking the state, just as I've asked the EPA to find ways to mitigate some of those nitrate issues that's happening, not only with us, but the whole entire world. So water quality, water quantity. I think somebody had mentioned earlier that there's big issues with water, and there will become a day where we will not have water. And if we do have water, it will not be able to be drank. And what do I tell my people at that point in time? What do? It's too late. We've already saturated the most precious natural resource that we have. And if we don't have any water, we have no life, just as it is with food. So I'm asking the state to take a real hard look at finding a way to work with the tribes to help safeguard that natural precious water that we all need to survive in this world. We also are checkerboarded, so we have several producers within our reservation that are still using some of the synthetics in the agricultural model, which is one of the reasons that we're seeing the increase in nitrates. We're also seeing, you know, the Ogallala aquifer being depleted as well. We've been setting up our water rights for about, well, ever since I've been here, about 17 years, so we're still working through all of those. So hopefully our name will be on that list one of these days where we'll secure our water rights in the future as well. State-recognized tribes, that was mentioned by Chairman Rupnick. We, the Iowa Tribe of Kansas, Nebraska, do not support any state-recognized tribes coming in to the state of Kansas either. So I wanted to make that clear and well-known today as well. Other than that, there's still some taxation issues that we've got. You know, our reservation, we're pretty self-sufficient. We have our own economic development, we have our own clinics, we have our own law enforcement, we have our own road maintenance, and we're still today maintaining all of the reservation land, the roads, the right-of-ways, everything within those borders of the reservation, which is causing some issues as far as taxing on the property. So there's property taxes that's being collected from my members. But like I said earlier, you know, those property taxes should be paid directly to the tribe because the tribe is the one that's maintaining the roads, keeping those, you know, we've just spent, you know, upwards of $6 million for an overlayment of an asphalt project within our reservation. But the county is getting all of the revenue off of that, and we're got the expense of maintaining and operating all those roads, and all of the landowners within the reservation pay taxes elsewhere as well. So that is hurting and affecting the tribe, not only for the short term, but for the long term as well. So I'm looking for solutions to find with you to help mitigate some of these issues we're experiencing and have been experiencing for a number of years. So with all that being said, I appreciate the time today. I know that you guys got a lot of things going on, as we do too, but I think this could be a new beginning to where we can, you know, foster and develop that long-term relationship, because I don't think the state of Kansas or the Iowas are going anywhere soon. So if we can just find a way to work together for the greater good of all, I think that would be great for every one of us. So again, thank you, and I appreciate your time.
Thank you very much. Committee questions? Thank you again.
Thank you.
Next, we have the Kickapoo tribe. Howard Allen, are you up first? Okay. Tribal Council Secretary. Howard, welcome to committee.
Good afternoon, everybody. My English name is Howard Allen. I'm Kickapoo in Kansas, Tribal Secretary. First thing I want to talk about is sovereignty. Is somebody running a PowerPoint here? Okay. So, in talking about sovereignty, going back in history a little bit, we as the Kickapoo people were a complete sovereign tribe, which meant when we were sovereign, we chose who we fought against, who our enemies were, who we made peace with, and as a result, we signed many treaties. We agreed to many agreements. Where you call them treaties, we call them nakonikanen, and there's some of them on there. That first part is blocked, but we made agreements. Our latest one was 1853. We're here in Kansas that we agreed to adopt some of the Potawatomi into our tribe. Can you go to the first? Yeah, okay. We have made agreements, treaties with the country of France, Great Britain, Spain, Mexico, and of course the United States. And we have a previous gentleman, I don't remember his name, he's a professor. He said that we had 4 treaties. No, there's a lot more than that. Can you go to that first slide? So the very first one that we made with the United States, Treaty of Greenville, 1795. Another one in 1803. 1819, you notice there were 2 treaties, one with the Kickapoo proper, one with the Muscotan band, AKA Muscoteaki. And 1822, 2 treaties as well with the Kickapoo and Muscoteaki band. 1832, which removed us west of the Mississippi River, and 1854. Can you go to the next slide, please? So, 1832 treaty. There's some of the language in that treaty there. You notice there's no mention of the state of Kansas. Our people did not know what the state of Kansas was. It just talks about the reservation being southwest of the Missouri River and so forth. So there are enumerated rights in that treaty. One of the most important ones is it established a permanent place of residence, which leads to our reserved treaty rights, such as hunting. We have and still preserve our right to hunt. There are times when we hunt for religious ceremonies. So sometimes in the eyes of the state of Kansas, the game warden, we are criminals. When there's a ceremony that needs to be conducted, we hunt. Sometimes our people are arrested. But we have the treaty right to hunt. We have the treaty right to fish, gather, such as gathering traditional medicines, things that are needed for traditional homes and so forth, and of course, water rights. Next slide, please. There is our 1832 Kickapoo Reservation. Basically from the Missouri River out west to about 30, 40 miles. Then we fast forward to 1854. Go ahead, next slide. Oh, before I go there. So all these treaties that we made with the United States and the other foreign governments, we recognize their sovereignty, they recognize our sovereignty. These three Kickapoo tribes, we are all descendants of the Kickapoo. There was no treaty made with the Kansas Kickapoo, no treaty with the Kickapoo of Oklahoma or Texas Kickapoo, one Kickapoo tribe. We're all descended from that group. Therefore, we all maintain those treaty rights. And I'm kind of disappointed. Of course, we were invited here. You did not invite them. But some of the younger people in here that you see sitting here are from the Oklahoma Kickapoo and Texas Kickapoo, here to observe this. So we have basically 4 reservations. The one here, there's kind of a semi-reservation in Oklahoma. It's called something else. We have a reservation in Texas, and we have a reservation in the state of Coahuila, Mexico. And that goes back to the agreement with Mexico. Next slide, please. So 1854 treaty. Basically, that diminished our reservations, but none of those reserved rights were diminished. We still maintain them, and we still practice those rights. Next slide, please. So that's the diminished reservation. That is our legal reservation right now. Next slide, please. Now we get into some of your laws, and Chairman Rupnick, already mentioned some of this. The Kansas-Nebraska Act. So I highlighted some of those. He already read some of that. That basically, for you, and keep in mind, in 1854, Kickapoos were not citizens of this country. So when I say you, as Kansas, your ancestors, to be part of the Kansas territory, you agreed to this. And it did not include the Kickapoo Reservation as being part of the state of Kansas because we've never consented, similar to what Chairman Rupnick said. Also, that you agreed not to impair the rights of person or property. And we're going to talk about taxation a little bit later. And we believe you are impairing on our rights to govern, to tax. Next slide, please. And of course, in order for you to join the United States, 1861, basically the same language is put in there, that the reservation shall not be part of the state of Kansas unless the tribes consent. And I can't speak for other tribes, but the Kickapoos have never consented. And the same language is in there about not to impair our rights of persons or property. Next slide, please. So in 1937, Indian Reorganization Act, this was our first constitution. We used to have traditional forms of government. So in 1937, we switched to quote unquote IRA government. So that's what our tribal council is today. In our Constitution, up there is Article 1. Gives our jurisdictional territory of the 1854 reservation. Next slide, please. So we have a lot of issues with the state of Kansas on taxation. So we see that you have no statutory authority to tax us. The Kansas Act gave you criminal jurisdiction over us. Of course, that's federal legislation. But the Kansas-Nebraska Act and the Act of Admission, where you joined the United States, you can't impair on our rights. And taxation is governing. In Brown County, recently we had to pay taxes to Brown County. They taxed some of our property as a sovereign nation. We did it under protest, but nothing's become of that. So under your laws, the way I understand it, churches, states, federal properties, state properties, municipal properties are exempted from state taxation. We are not. You tax us. Not only that, we had to pay taxes on our Head Start. And I believe your laws say that schools are exempt, but part of our Head Start is not exempt. And I looked at the other Head Starts in Brown County. They don't have to pay it, but we do. We believe we have the statutory authority to tax other tribes on our reservation, but income taxes, for example, Potawatomi, Sac and Fox, Ioways on our reservation pay income taxes to you. We're the ones that has the authority to do it. And we do pay taxes. We receive very little back from the state of Kansas. We have our own school, Kickapoo Nation School. We get nothing from the state of Kansas. We have our own police force, fire department, our roads program. We get very little, if anything, from the state of Kansas, even though a lot of our non-Indian neighbors, farmers, they benefit from our police department, our fire department, and of course, our roads. There's mutual aid. Like if there's a fire in a neighboring town, our Kickapoo Fire Department goes over there to help them, and vice versa, they can help us, and we appreciate that. Same with the police department. Next slide, please. So, what is the solution? Maybe that's it. Other tribes and states have entered into tax compacts. Some of them listed up there, Tulalip, Cherokees, Navajos. There's probably more there than is listed. Next slide, please. There's some more tribes. And the next slide. So that's our question. What do you want to do, if anything? We think it would benefit us. We think it would benefit you as a state. But we are a semi-sovereign government, as are you. Any questions?
Committee questions? I think just from our standpoint, we're just trying to gather information and absorb all this. So a lot of this, I think the committee's first time hearing these kind of issues. So we're going to dig into it. Representative Tarwater.
Thank you, Mr. Chair. Do you pay income tax to the state of Kansas as well?
Do I personally?
Does your tribe?
Not on the reservation. If we work off the reservation, yes.
Right, thank you.
Further questions? Senator Alley.
Thank you. The tax that you pay for property tax, who does that go to? Do you pay property tax on your residents, for instance?
In the tribe, we pay that to Brown County, Kansas.
Brown County.
And we did it under protest.
And within the property tax that you pay to Brown County, Kansas, are they providing any transportation, any roadways, or is that paid for by the tribe, the roads?
Well, like it's been mentioned earlier, our reservations are checkerboarded. So some of the roads are FAS road, federally assisted roads. So our Kickapoo Roads Department gets the money to fix and repair those roads. But there's other roads on the reservation. I assume Brown County pays for those roads. I really don't know. But we don't get anything directly from Brown County or the state.
Thank you.
Further questions? Seeing none, thank you very much for the information. Next, we have Eric. Eric, very good. Thank you for being here.
Sort of a last-minute thing, so you'll excuse me if I read prepared remarks before everyone. So, good afternoon. My name is Eric Sheets, and I am the Environmental Director for the Kickapoo Tribe in Kansas. At this point, it's been for a little over 4.5 years. In this role, I manage our programs under the Clean Water Act. Section 106 focuses on water quality. 319 focuses on non-point source pollution, and our wetlands program grant. And this is among other programs and initiatives. And these programs are essential for safeguarding our water resources, ensuring they meet both environmental standards and the needs of our community. So, as a member of the Kickapoo tribe, and through my study in environmental law and federal Indian law, I've kind of learned how to navigate the complexities of managing water resources while at the same time upholding tribal sovereignty and meeting federal regulatory requirements. More recently, I've focused on on upgrading our tribe's aging drinking water plant. And ensuring we remain in compliance with federal regulations. So today, I'd like to share with some of you, some of the challenges we face with our water resources and infrastructure, the steps we're taking to address them, and the importance of collaboration between the tribe and the state for a more sustainable future. So the Kickapoo tribe depends entirely on the Delaware River in Brown County for our drinking water. And this reliance has not come without significant challenges. The state of the watershed and upstream activities directly impact the quality and reliability of this critical resource. So I'm going to walk through some of the key issues we face with using the Delaware River as our sole source of drinking water. Nutrient enrichment is a major concern. Agricultural runoff upstream brings high levels of nitrates and phosphorus into the Delaware River. These pollutants, primarily from fertilizers and animal waste, can lead to harmful algal blooms and deplete oxygen levels, threatening both water quality and aquatic life. High nitrate levels in particular pose serious health risks, especially to infants and the elderly. As a result, we frequently have to take costly measures to ensure that our water meets EPA safety standards, which is a strain on both our resources and infrastructure. Sediment loading further complicates our water quality issues. The sediment comes from various sources, stream bank erosion, agricultural runoff, and poor land use practices. And it doesn't just make the water murky, it carries other pollutants like phosphorus and heavy metals and puts extra pressure on our water treatment systems. This increases wear and tear on the equipment, which drives up both operational costs and maintenance needs. Bacterial contamination adds another layer of complexity. Fecal contamination from livestock and inadequate containment practices upstream results in high levels of bacteria like E. coli in the river. These bacteria levels frequently exceed EPA safety standards, forcing us to issue boil water advisories and invest heavily in disinfection processes. The inconsistency in bacterial loads makes it a consistent challenge to provide safe drinking water. Then there's the issue of drought vulnerability and seasonal variability. The Delaware River is highly susceptible to fluctuations in flow, especially during dry seasons or periods of prolonged drought. The drought of 2003, for example, forced us to truck in potable water, a costly and unsustainable approach. And climate change is likely to exacerbate a lot of these conditions, making the river an even more unreliable source for the future. Low flows in the river also concentrate pollutants, which further complicates our water treatment efforts. These environmental challenges are compounded by upstream land use policies that often don't prioritize water quality or consider the downstream impact on the tribe. And this underscores the need for more coordinated watershed management that includes all stakeholders, especially the tribe whose drinking water comes directly from this river. These environmental challenges, given these conditions, it's clear that relying solely on the Delaware River for drinking water is not sustainable. To address these issues, we need a comprehensive approach, upgrading our infrastructure, improving land practices, controlling pollution, and exploring alternative sources of water. And this brings me to my next point, the state of our water infrastructure and the steps we've been taking to mitigate these ongoing challenges. So adding to our water quality issues is the reality of our aging water treatment plant built back in 1977 as a temporary solution. And the water treatment plant was never designed to handle the levels of contamination or the variability in water quality that we're experiencing today. Our filtration systems are outdated, our sedimentation basins are undersized, and our disinfection units are insufficient to address the bacterial contamination we often face. Meeting safe drinking water standards has become an ongoing battle for the tribe. And our water distribution system is equally problematic. It's old, leaky, and lacks the resilience needed to cope with emergencies or changes in water quality. And recent storms have exposed these vulnerabilities, knocking out our primary control computer and damaging a lot of the critical components necessary for the treatment process itself. And these risks are real for our community, and they are not dissipating. Originally, the reason why the tribe's water treatment plant was built as a temporary measure is we aimed to develop the Plum Creek Reservoir project to secure a more reliable water source. However, that effort stalled due to land acquisition issues and resistance from non-tribal landowners on the reservation. So even attempts to use the Nemaha-Brown Watershed Board's condemnation authority were blocked because they refused to allow tribal representation on the board. After years of litigation, the court finally ruled in favor of the tribe in 2014, effectively affirming our water rights. But by then, the momentum for the Plum Creek Reservoir project had stalled, and a lot of the funding opportunities we had lined up at the time had evaporated. So we had to change course. Recognizing the limitations of our existing infrastructure, we shifted focus to improving our existing water treatment plant, and more recently, we've begun exploring new groundwater resources that could either supplement or completely replace our current dependence on surface water. So despite these challenges, the tribe has been proactive in pursuing multiple strategies to improve water quality and to secure a reliable water supply. And we've, as it's turned out, taken a three-pronged approach, reducing pollution at the source, upgrading our treatment facilities, and exploring new water resources. First, and kind of for the longest time, we've been tackling non-point source pollution head-on. Understanding that much of the contamination comes from upstream, we've engaged in extensive efforts to manage and mitigate these impacts. Through a watershed-based planning framework, both on a tribal level and as part of a broader initiative with the RAPS, the Delaware River RAPS, we've implemented several impactful projects. So by stabilizing eroding stream banks along key waterways like Plum Creek and Squaw Creek, we're reducing sediment loading into the Delaware River and preventing additional pollutants from entering the water. And positive outcomes are already evident from this effort with decreased erosion rates and lower sediment levels downstream. Restoring wetlands along riparian corridors has created natural filtration systems that trap sediments, nutrients, and other contaminants before they reach the river. These restoration efforts have improved water quality and provided crucial habitat for wildlife, kind of enhancing the overall health of the watershed. Installing riparian buffers between agricultural land and the river helps capture runoff and to filter out contaminants like nitrates, phosphorus, and pesticides. So kind of by focusing on this revegetation with native species, we've also worked to stabilize the soils and reduce erosion. We've also made significant investment in our water treatment plant. Over the past year, we've invested nearly $500,000 in critical upgrades, moving beyond just routine maintenance to focus on targeted improvements for better reliability and efficiency. Outdated and storm-damaged electrical panels, control systems, wireless communication equipment have been replaced, ensuring that there's more stability and reliability in the plant operations, especially during extreme weather events. Key mechanical parts like pumps and valves have also been upgraded. These components are essential for intake, filtration, and our distribution processes, and their replacement has reduced breakdowns and overall improved the plant's capacity to handle the fluctuating water quality conditions present in the Delaware River. Additionally, and most recently, we were pursuing new groundwater resources as a potential alternative or supplement to the Delaware River. Recent groundwater studies have identified 4 different aquifer systems that could potentially be used to provide reliable water resources. Tomorrow, in fact, the Kickapoo Tribe will be meeting with the U.S. Geological Survey and their engineers to review their recent subsurface water imaging efforts. And if these findings confirm the potential of these aquifers, the Kickapoo Tribe is prepared to move forward with the development of these resources. And this shift could significantly change our water strategy, providing a stable and sustainable supply and reducing our vulnerability to the Delaware River's unpredictability. So as we look ahead, it's clear that sustainable water management on the Kickapoo Reservation will require continued collaboration and partnerships between the tribe and the state of Kansas. I do want to commend the Kansas Water Office through their state water plan for recognizing the importance of including tribal interests. The recent planning session I attended in Lawrence was a valuable step forward, allowing space for tribes to voice concerns and priorities about water resources. However, there's still more work to be done to ensure a truly collaborative approach between tribes and the state. The relationship between the state of Kansas and the tribes is fundamentally a government-to-government relationship, and that should be reflected in how tribes are engaged with in the planning and decision-making processes, not just as stakeholders, but as sovereign governments. So to that end, I'd like to propose several ideas for enhancing collaboration and providing legislative support to ensure tribes like ours have access to healthy and reliable drinking water. And again, these are kind of bifurcated into 2 different areas, engagement and collaboration on the one hand, and legislative support on the other. So creating a dedicated tribal advisory council would enable tribes to participate directly in state water planning, policy development, and decision-making processes. This council would ensure tribal voices are integrated into all stages of water resource management, from policy formulation to implementation. Involving tribes more deeply in these processes would help align state and tribal water management goals better. Providing technical assistance and capacity building programs tailored specifically for tribes is another important step that the state can take. This could include training for tribal environmental staff, assistance with water quality monitoring, or technical support for implementing advanced water treatment technologies and exploring groundwater resources. Encouraging co-management of shared water resources is essential for effective collaboration. So creating joint monitoring and response teams that include both tribal and state representatives would allow us to better address issues like droughts, floods, or contamination events, ensuring that both tribal and non-tribal lands are considered in management plans. So next, some legislative support ideas. Stricter limits on nutrients and sediment runoff from agricultural lands, particularly upstream of tribal water intakes, are necessary to protect source water quality. Legislation could mandate buffer zone requirements, set limits on fertilizer applications, or establish riparian buffer zones. These measures would help reduce contamination risks to drinking water sources and improve water quality not only in our neck of the woods, but across the state. Encouraging sustainable agricultural practices is essential for reducing runoff and protecting water quality. Developing state incentive programs for farmers and landowners to adopt methods like no-till farming, cover cropping, and constructing vegetative buffer strips can significantly reduce nutrient and sediment runoff. These practices benefit both agricultural producers and downstream water users, including the tribe. Finally, supporting drought management planning and adaptation is important as well, as droughts pose a significant risk to the tribe's water security. State-level drought management and adaptation plans should include tribal input and participation, considering the unique vulnerabilities and insights that tribes offer. Legislative support could also ensure these perspectives are incorporated and that tribes have the resources needed for drought preparedness in response. So that's kind of wraps it up. Thanks for your time today and considering these points. I do hope that it will spur further discussion on your end and then ultimately across the table with tribes. And if there are any questions I can address, I'd be happy to take them.
Very good. Thank you. Committee questions? Seeing none, thank you.
Thanks a lot.
Next, we have Gail Cheatham. Gail? Okay. Didn't know if you heard me. Very good. Thank you for being here.
How you guys doing? This is a lot. It's a lot to take in, especially for any of the members who've never had to deal with tribes before. So my name is Gail Cheatham, I'm the chair of the Kickapoo Tribe. I'd like to thank our Secretary Howard Allen for his overview of our reservation, and to Eric for one of the most critical issues. Although we have a lot, our water is one of the critical issues we have with our tribe. So I come before you today. You have seen a lot, you had some recommendation, and I just had one recommendation. The National Conference of State Legislatures recommends the creation of committees within the state legislature. These are committees, like a subcommittee. Several states have them that have tribes that they work with to come together. A lot of times our legislatures, pass laws, and then there's this whole after effect. The tribes, because of our federal status and our sovereignty, should never be an afterthought. So all of you are sitting, and I looked you up, on various committees. So we have health, we have the Indian Child Welfare Act, and you sat here and listened to the complexities of federal Indian law. I'm a tribal member. It is hard for me to understand it. These lawyers, like you heard the different tribes, they hire lawyers because it is very complex. Sometimes I feel like we live as tribal members, it's a constant federal Indian law 101. Why we're not considered, why we're not in a race, what defines us as a tribal member, and people don't understand it. So it is very complex, and it's a lot, especially we have some tribes that border other states, like you heard with the Iowa tribe. So I'm recommending for consideration to form under this National Conference of State Legislatures to look into that, to establish these subcommittees. That would be where we would come together with issues. It's just, another committee, but to come together and talk about issues that are going to ultimately impact tribes. That is what I'm requesting. And I was here, I've been around, Zeke Repkini, his mom's been around. I mean, we've been around for a long time for these different committees since the inception. And Dennis Hodges was one of my best friends. And he would email us, the tribes, anything related, something's coming up in the state legislature, and would let us know. So we would at least, if we knew ahead of time, we could, propose our, talk. And I haven't seen that. Only been in here for a year. I can't speak for the Iowas or the Sac and Fox or any of the other tribes. So, but he was really good about it. He would notify the legislatures, he would notify the tribes, and we'd have the opportunity to come. But it is not, when we look at the budgets, we look at our budgets as tribes, looking at the state budget, where's the cuts gonna be? But it is not cost effective to not collaborate and do consultation with tribes. It's costly when you have to go back and then you have to litigate. The state doesn't win. I mean, it doesn't win. And who ultimately pays? Us as taxpayers. Somebody asked, do you pay taxes? I work on the reservation. I pay taxes. I live in Shawnee County. So, and a lot of us, we work up there, but we don't live there. We have tribal members that live on the reservation. They are paying taxes. And we had a couple that went up to the Brown County Tax Board, the commission, and they said their property taxes doubled. They're on fixed incomes. They are seniors. So when you're looking at a fixed income and your taxes are raising and raising, and then, they were asking, they came and talked to us, how are we benefiting by paying Brown County those taxes? What are we getting in return as a taxpayer? So I'm just saying that look at it, maybe, talk amongst yourselves, but that's what I would recommend. They're working in a lot of different states. That's all I had. Did anybody have any questions?
Committee questions? Thank you very
Thank
much
you.
for being here. I want to take this time to apologize to the Kickapoo Nation for not including the other tribes. It was not meant as a slight or anything like that. We might need to improve, and if someone could get us some contact information, so that we could make sure that never happens again. So I apologize for that oversight, overlooking, or whatever you want to call it, and we will make sure that doesn't happen again. So with that, committee, I think kind of the plan is to kind of have staff gather some of these pertinent ideas, all of them, and then we at a future date would take a look at which ones we think we could tackle. Some of them obviously have been ongoing for a number of years, and I'm not sure when it deals with the federal government that we have a lot of authority, but there are things, I think, on the state level that have been brought to our attention that we may be able to deal with. So at this point in time, Unless somebody has a committee recommendation right now.
Thank you, Mr. Chairman. I do have a thought. I do have a thought. Could we email staff with ideas that we heard here ourselves and then compare the list to see what, when we get together, that we could build? Because I did take some notes on things that I heard. I'd like to know more information about hunting license that falls under Department of Wildlife, or taxation. What do we do as a state, since I don't sit on the tax committee? And then water, with the Department of Water, where do they have a liaison with the water department? There's some questions that I have that perhaps we can look at, but I'm not ready to make recommendations because I don't have enough facts. Thank you.
And I think that's a good idea. So if you guys want to email to Elena and Kate, any thoughts you have about this, and then they'll prepare their own remarks from this of targeted things that have been mentioned here that we can take a look at, maybe find out some more information on those items, and how, like Senator Alley mentioned, how the tax situation does work, and property tax wise, and how it goes, and how they split up the money, or if they do, to maintain the roads and that kind of stuff. So Representative Alcala, did you have a question? Or?
I have a recommendation, but I do have, well, maybe it is a recommendation. Mr. Chairman, if I'm out of line here, you pull me in. I see Brad sitting back there. Brad, are you a lobbyist for one of the organizations? For who? Prairie Band. So I'm having deja vu here. I've sat on one of these committees, on this committee several years ago, and I'm hearing repetitive some of the same issues that are coming up. And if we don't have a roadmap, we'll leave here, we'll meet again, we'll have the same thing we said we met, and it's unfair to the groups that have came here and did the presentation. My thoughts is if all the tribal councils could get together and have one lobbyist, not multi-lobbyists, but one lobbyist, and then legislative priorities are sent forward to this committee, at least we'll know, because if we try to figure out what we can fix and what we can't fix, there's tons of issues that came across the table today. But if they have legislative priorities that we can address and focus on, I think it narrows it down and we get something probably more accomplished than trying to accomplish multi-things. The hunting license, I don't know why we don't do it like we do the veterans. I mean, you just don't charge them, you know. And so, but I think that I'd like to see legislative priorities, because we know we're not going to be able to do all these because it just doesn't work for anyone. If we have priorities, we can look at priorities and try to make them work through this committee. So that would be my recommendation, that the tribal council get together and get a lobbyist, and that gets Brad is with the Perry Band. But I mean, you get multi-lobbyists, and what happens is you have the whole same group of legislative priorities that are all different, and then nothing gets accomplished. But at least we'll have a roadmap, and when we come back, we don't have to listen to the same issues again, and then nothing happens. At least if we have the legislative priorities, they can come back and hold us accountable and say, hey, we gave these legislative priorities, and we can even we'll have an answer for them, why we could, why we couldn't.
I think that's a good idea. On one of the committees that I sat on, probably nobody in this room sits on it, but the CanCare Oversight Committee, that's what we do. We track, we meet quarterly, and we keep track of those issues ongoing until they're solved, or there's some kind of a reasonable explanation of why they can't be solved. So I think that's a good idea to start this through this process. Committee, from what I've heard today, we may be meeting more than we have for a while with these issues to deal with them. So stay tuned. Senator.
I had another thought. Thank you, Mr. Chairman. If Janicita, maybe she could help spearhead this with us, that we have a working group of some sort that brings these ideas to us. To me, she seems like maybe the clearinghouse to get the ideas all together as well, and working with legislative staff. I think she would be a very key person if she'd be willing to work with us. I'm happy to help anyhow you'd like to, Mr. Chairman.
Further discussion. I think we've got a path forward. Do we agree on that? Very good with that. And thank you, everybody, for coming. I know your time is valuable, and we appreciate every bit of it. Staff, thank you again for the wonderful presentations and all of the information that we've learned today, which has been like drinking from a fire hose, if I can say that again. So very good. With that, we're adjourned.